attorney. So I de-emphasized the defense on that, and that's the only change to 19. There were some typographical errors from what you guys had. I gave you all last night, and I think there was a duplication on the theory of defense. So, Mr. Champagne, as to instructions that I've tendered 1 through, I forgot already, 26, do you have any further instructions to tender, any objections, or anything you want to say about them?
Judge, just that I think we're going to hold off discussion on number 7. But,
correct.
We're just going to review one more time the verdict forms and make sure that we feel like they flow correctly and everything like that. But other than that, no objections or other instructions.
If you have a problem with the verdict form, then I want you to tell me while we're on the record. Okay. And we will go ahead and listen to what the defense has to say. And Mr. Moran, I have marked defense tendered 1 through 7, and I know you gave me another packet that were things that were filed before, which I think are adequately covered in the instructions that I've given. I will mark those all starting at number 8, and I'll do that individually for the record. So defense tendered 8 through whatever you gave me. Do you have anything to say about the instructions that you tendered 1 through 6? And you don't have to if you don't want to.
I don't know. 1 through 6. I've got.
No. So I gave you things that I've already numbered 1 through 7. One pack of 1 through 6. This is stuff we talked about last night. And then we're going to talk about 7 because there's so many different versions of 7. We're going to talk about that separately.
I don't know how many files I've got now, but what I have here looks like your handwriting. Defense tendered 1, 2, 3.
Okay, there should be
4.
another. It should be. Well, let's talk about 1 through 4, and then we'll talk about the other ones.
And then I've got another file that's got an instruction defense 7A, defense 7B.
We're not talking about 7. Let's talk about 1 through 4. Is there anything that you want to put on the record?
Yes, with respect to defense tendered 1.
Okay.
It's marked defense tendered 1, handwriting, capital D, lowercase t. This is the defense effort to put human remains protection dogs in their proper context. This is a super controversial issue. It's being heard and moving towards resolution across the country. The problem is when these dogs are treated as definitive substantive proof, there's a dead body in a location, as the court's well aware after having litigated this, that that's not the case. These dogs are allergic to fingernails, hair, blood, things from live humans. The problem in the hands of the jury without proper instruction is that folks will think that humans or dogs don't lie, assign special credence to the animals, and decide cases that because a dog wouldn't lie to us, the dog said there was a dead body here, that there must have been a dead body, and in this case, that would mean a dead body in Mr. Redwine's house and his truck, despite the fact that, as has been testified to for days and days now, innocent remains that fall from live humans cause dogs to indicate. In this case, we had vastly more false alerts or alerts where no evidence was derived than anything else. In fact, I can't think of a single thing that a dog alerted to that led to any substantive proof. That's why we're asking the court to instruct the jury that they need to carefully consider this in its proper context, that as even a state witness was testifying that these dogs should be considered tools and not substantive, definitive evidence that there's proof a deceased human body was present, unless, of course, an actual body is discovered, and that was obviously not the case. So I'm happy to work with the court on this instruction. Your Honor and I were here until I think 8 o'clock last night.
And I was here longer.
I finally walked through the dark hall somewhere around 8. You know, I know that Your Honor's been working hard on the instructions, and that we're a little pressed for time this morning, but I'm happy to work with the court and counsel on honing this and crafting it in a way that would satisfy everyone. But I think just getting rid of this altogether creates a really dangerous situation, and I have reason to believe that because of all of the challenges nationwide and the lack of standardization with respect to these animals, that there is going to be higher court rulings on this issue coming to a courtroom near you. So I would request that we treat it with the caution it deserves. This is our chance.
All right, Mr. Champagne, did you want to respond?
Judge, we do object to this defense standard 1. It's our position that this unduly highlights that particular set of evidence. It's argumentative and inappropriate for court instruction to the jury on that topic. I can give more detail if you like.
I'm going to not give defense standard number 1. I believe it's argumentative. It's something that counsel can make an argument based upon the evidence at trial. During closing arguments, I'm not going to instruct if there is a defense standard case which will be given. And it unduly highlights the dog evidence. There's plenty of evidence the jury can decide what way to give the dog evidence if they want. Defense number 2, Mr. Champagne. I'm sorry. Number 2.
Would you like me to comment on number 2?
No, I said Mr. Champagne didn't answer.
That's okay.
Mr. Moran.
Your Honor, this one addresses the unconscious bias that we do not want in the deliberation room. I'm frankly sort of surprised that progressive prosecutors would object to this. This is a problem in our country that we are growing in our understanding of, and a juror back there who's experiencing people suggesting that decisions be made based on stereotypes, attitudes, or preferences that people may consciously reject, but may be expressed without conscious awareness, control, or intention, that they're not armed with this instruction is a real problem. I think that that problem is exacerbated by the fact that we tell people to base the decision on their experiences in life, which is, of course, something that needs to happen and is an appropriate part of deliberation, but not if that experience in life is an expression of unconscious bias. And I want to arm a juror who's recognizing that happening with this instruction. It embodies a higher calling of citizenship in this country, and this is the type of thing that we need to move away from, or decisions being made without awareness of that bias. It's something that this country needs to move away from. This instruction helps in that regard. And as Mr. Champagne was saying yesterday, he may believe this on a personal level, but doesn't think that a jury should be instructed this way is distressing. This is something that we should be aware of and incorporate into deliberations and decisions in the courtroom. That's to have intended to.
I'm sorry, I interrupted.
It's something we should be aware of and incorporate into deliberations and decisions in the courtroom.
We'd ask to provide defense tender 2.
Excuse me, Mr. Champagne.
The people do object, Judge. While I may personally believe these things are good and think they should work towards, I don't think a jury instruction, much like a trial of child abuse and murder, is the right place to bring these issues forward. We object, and I don't think it has any basis in law, and it's not proper for court instruction.
The court's going to deny defense tender 2. The instructions already talk about how bias is not to influence the juror's decision. That's already in there. I don't know how one paragraph is going to give jurors any education in unconscious bias that they don't even know they have, and what good it's going to be. So number 2 is not going to happen. Defense tender 3, I don't know if we put this on the record before. It's about unanimous unanimity instruction. I don't think we did, but we did talk about election. So we probably ought to talk about this also. So Mr. Moran.
One or the other, Your Honor. I mean, at some point, the prosecution is going to have to identify what the theory of Dylan's death was, and they haven't, and they're objecting to unanimity. So now the jury gets to go back there and decide that we could make this call with you thinking, with there being a myriad of different acts that may have led to the results. So there's just no unanimity required with respect to the actus reus. It's a real problem, and it goes to the heart of protections Mr. Redwine's afforded under the U.S. and Colorado Constitution. So this is last chance. You know, there needs to be unanimity. That is a basic tenet of due process, and failing to have an election or unanimity instruction leaves this jury running wild. They're free to decide this case as individuals, but with respect to guilt instead of the individual basis by which they could establish or find doubt. They're not supposed to have an individually decided mens rea, actus reus, and that's what happens without a unanimity instruction or the election that we've requested. So I'm strongly urging the court to provide one of these.
All right, Mr. Champagne.
Judge, thank you, and respectfully, the cases on point are People v. Archuleta, 467 P. 3rd, 307, People v. Hanson, 928 P. 2nd, 776, direct quotation, People versus Webster Gravel, Garvelle, 465 P. 3rd, 570. Unanimity is generally required when we're talking about numerous sets of facts, such as a pattern of child sex assault or numerous sets of specific and discrete factual episodes. As noted in Archuleta from the Colorado Supreme Court, quote, neither a prosecutorial election nor a modified unanimity instruction is required. However, when a defendant is charged with engaging in a single transaction criminal conduct and the prosecution proceeds at trial on that basis. That's exactly what we have in this case. We don't think unanimity nor election are required.
Okay. Your Honor, before we move on from this, they haven't done it. They didn't do it in opening. They're not doing it now. They haven't ever told anyone how this child died. There's some loose suggestion of blunt force trauma. There's discussion of cut marks on the child's skull. This is a huge problem.
All right. Court is going to deny defense standard number 3. I agree with the prosecution. This is a hugely certain. Hearing an argument on this one just because I think that the elements and the instructions totally cover what the jury can consider and not consider, and I'm not going to give number 4. Number 5 should be incorporated in 7. It was the theory of defense destruction before I went through and made all the additional, well, until I got all the different versions of the theory of defense. Number 6, I'm not sure that you have this.
Your Honor, I don't have 5 or 6, and I think it's not a good idea to move on from 4, especially considering the refusal to give unanimity.
Mr. Moran.
On 3 to move off from 4.
Number 4 is simply mere presence at or near the scene of a crime without more is not sufficient to establish criminal liability. That is true, and that is adequately covered in the instructions as the burden of proof. What has to be proven? We're moving off of number 4. Number 5 is covered in number 7, is what I'm telling you. I know you don't have it in front of you, is what you told me. You have it there somewhere because I gave it to you last night after you left. But I know you have a lot of different pieces of paper.
You gave it to me after I left.
I left it on your table. And it was your initial theory of the defense instruction, which is incorporated in number 7, is what I'm telling you. That's why I don't particularly think we need to talk about it, because we're going to talk about number 7 in just a minute. So that gets us to number 6, which is, in order to convict the defendant of child abuse resulting in death, you must unanimously agree that the defendant committed the same act or acts, or has committed all of the acts alleged. which goes back to unanimity. I'll make more argument on 6. Want to see what, do you want to see it? Yeah. You have it, Mr. Sheehan. And I put them both on your desk.
I'll take a look at this thing, copy it, kind of the same problem, right? There's a lot of pieces of paper.
Okay.
Judge, I mean, as you can see, there are several piles here, but
I'm not criticizing you about it. It's just, I know it's confusing. But you have it in your hand right now. Is there anything you want to say about it?
yeah, give a unanimity.
That's right.
We need a unanimity instruction.
I'm going to show it to Mr. Champagne. And then I need that back when you're done, Mr. Champagne. Anything you want to say?
Judge, it's the same record I made just a moment ago. We don't have a situation where we've got multiple different sets of events. We have one single unified event, and therefore unanimity is not required.
All right.
So just to make sure that we're constitutionalizing this, we're making this, we're offering that the U.S. and Colorado Constitution, Article 2, Section 1625.
For the same reasons, I'm not giving number 3, I believe. I will not be given number 6. Okay, number 7, you should have, and if you don't, I'll make another copy of it. 7A through 7G, let's see, 7G. 7A is the one that we talked about yesterday, that we initially talked about putting into the instruction packet. And that is currently in the packet of all the instructions that you have, but I'm willing to swap this out if everything. So I'm willing to listen to it and perhaps swap it out. The very first one, 7A, is one that if I was going to give something, I believe Mr. Moran wanted me to take, I actually had something a little bit more in there, and he asked me to take out a paragraph. So there's all sorts of various versions, Mr. Moran. I don't know what you want to say about which one you want to give.
7A, but as has been previously noted in this instruction conference, I was here until 8 o'clock. Your Honor was here beyond then. I repeatedly sent efforts at meeting the needs that had been expressed in a limited way. Yesterday when this came up, yesterday when we were discussing the defense theory instruction, I thought to have input from the prosecution about their complaints. I think it's just a generalized complaint about providing a defense theory of the case instruction. I was here willing and ready to work with Your Honor to hone this and make it look how the court and counsel would want it to. The way it's written by the court, I don't know if we've got the version in here that we changed. I mean, the first iteration talked about how the defense counsel was saying that there wasn't enough blood to test in the living room, which is hopefully not a point that we ever conveyed to the jury. So it moved into a different iteration that I think is like the Saturday Night Live version of the defense. This looks like a skit rather than what we're trying to say. I know that Your Honor expressed some concern that 7A was a little long. That, I think, is a matter of course when you're dealing with a case that has been going since 2012 and where we spent a month presenting information to the jury. I filed, I think, 5 different versions of defense theory of the case. Didn't hear anything from prosecution or Your Honor. The 7, as it currently stands, I believe is in what Your Honor intends to provide to the jury, is the first sentence and last sentence. So I think the last sentence is one that Your Honor wrote, but it cuts out all the rest. And I think that's a real problem with the amount of information this jury's been provided, that the defense theory of the case instruction is so little down.
I would point out, now that I'm looking at it, 7B was the instruction that I initially offered to give to the defense, but they wanted me to take out some more paragraphs. So if you want to comment on that, you can. If you don't want me to, we won't.
It's tough to comment on that without feeling like I'm gonna get yelled at.
Well,
It excludes the critical information about animal damage to the skull and the bones of the child. I mean, like some of the most critical evidence in this case. It excludes discussion of the dogs, which is the absolute only way the government puts a dead body in Mr. Redwine's house. The exclusion of that critical information and inclusion of the stuff that we have tried to present and put in its proper context, like the Chiquita banana sticker. We do not mean to reduce our defense to the banana sticker in a bat or that made it onto Dylan Redwine's shirt. I mean, it's like a caricature of what we've been working on for years now. So I'd request that some version that discusses the photographs, that the DNA is in a quantity, at least, that is unsurprising where humans live, doesn't prove a violent crime by itself, that the animal damage is uncontroverted, that human remains detection dog indications are not evidence of death, only that human remains are present, because we are all shedding human remains throughout our lives. The descent identification lineup was conducted by an uncertified dog. I mean, what I've included in here is facts beyond controversy. With the possible exception of law enforcement not adequately developing exculpatory evidence, but that was the one part that the court expressed a willingness to include. But our defense is not just taking exception with the failure to develop exculpatory evidence. There's more facets to it that are included in my efforts at working with the court and the government to create a defense theory of the case instruction that adequately conveys what we've provided the jury.
all right, Mr. Champagne.
Thank you, Judge. The case on point here is People versus Weiss, W-E-I-S-S, 717 P. 2nd, 511 from the Colorado Supreme Court from 1985. The theory of the defense instruction should be brief, general, and instruct the jury on the legal effect of the explanation. Improper emphasis on particular facts is not favored. And an argumentative manner allows justifiable refusal of the court to give such an instruction. To be frank with you, I think probably the best version that the defense has presented is 7G, the very last one, because it does not overly emphasize the facts for the jury. I mean, we always have to consider that this is an instruction of the court being given to these jurors. And when we start getting into detailing of specific facts, as Mr. Moran has proposed, it begins to appear that the court is endorsing those facts or those conclusions regarding the facts that the defense has listed in their instruction. 7G basically just says that they have no burden, that Dylan Redwine left the home on the morning while his father was out running errands and was at work. So I think 7G is appropriate, and I think 7A is appropriate, but I think everything else between them unduly emphasizes the fact that and characterizes those facts in a manner that's favorable to the defense, which would be improper for an instruction from the court.
Okay, the court is going to, well,
If they're not objecting to 7G, we'll take it. I mean,
I'm getting there, okay? First of all, the court would like to point out that 7A came from what I provided in 7B because the defense preferred that over anything else, preferred 7A with less information over 7B. So that's why 7A was given. I am willing to give 7G. I don't have a problem with that. I think the rest of them are very argumentative. They're not brief. They are defensive, right? In certain parts of the evidence, it doesn't deal with legal theories. And we will replace what I have in there is number 7 with 7G. And, that will slow us down a little bit, but that's okay. So with that,
I'm sorry, Judge, I have a couple things I just need to put on the record as well.
Okay.
Relating to instructions.
and that's fine, I want to get done with, okay, that is somebody's, no equity, I guess. Is yours on? Yeah. Okay. That's okay, we haven't done it before, we're gonna have problems. Mr. Moran, so we have the ones that you went tendered. I'm gonna change 7. Anything else you want to put on the record about the instructions or the rate points?
Your Honor, as I understand what the court is directing us to do is to not go through each of these. I have provided defense tender jury instructions.
For the record, it was a packet that was handed to me in a manila folder this morning, and it appears to be the same as what was filed by the defense, I don't know when, quite a while ago. Is that correct, Mr. Moran? And you can look through there, see if there's anything else that you think, but
There may be an additional 1 or 2. I don't think there are many. But rather than belaboring all of this, because there are 35 pages of instructions here, the document goes pages 1 through 36, but 36 is a blank page. So 1 through 35, it incorporates the legal bases for the instructions requested on most of them. So adaptations from Colgi, taking things from criminal rules of procedure. There are case law citations.
Hold on just a second. I know that's all there. That's part of the record. I've looked at all the ones that have been provided previously, and I know I asked you to do this, so we have it all in one spot. My question is, if there's anything new that I haven't looked at, and that's what I need to know.
With the number of piles of instructions, I couldn't say.
All right.
I do not think so. The difference is that the one that was provided today has citations. I'm doing that because my understanding is that Your Honor does not want argument on all of these, that the legal basis will be made part of the record, and that's there included here. Unless the court wants any further record,
Only if there's something in there you think that we haven't looked at. I mean, because I don't know, it was just given to me and I haven't compared it. So I'm giving you. I mean, you've been looking through them. I know that, and I know it's difficult on you. This is the instruction conference, and so if there's anything specifically that stands out to you, just go ahead. If not, it's part of the record, and I will deny it.
my impression is that they're going to be denied, whether I make a lengthy record right now or not.
I understand that, and that's probably correct, unless you talk me into something, which probably isn't going to happen because hopefully they're all the same that you gave me before. But I'm giving you the opportunity if you want to make the record about anything specific.
Judge, I would have to go through all of them.
All right, that's fine. Mr. Champagne.
Thank you, Judge. Just a couple of quick points. The instructions with citations from defense counsel, as he noted, and the court noted, were submitted months ago at this point. I believe that was at the end of May. And the court has had the chance to review those. And we've had discussions about those last night at the preliminary conference today, this morning at the conference as well. Many of those instructions are based on opinions that the council has selected. I did want to cite a case I think is important on that topic. It's called Evans versus People, 706 P. 2nd, 795, Colorado Supreme Court, 1985. Quote, trial court's use of an excerpt from an opinion in an instruction is generally an unwise practice. And it goes on to talk at length about how opinions and jury instructions have very different purposes. It's like a quotation from an opinion, making a jury instruction is simply not a wise thing to do. Many of the instructions proffered by the defense fall into that category. Others make modifications to the Colgi instructions, which were very recent. I think 2016 is when the Colorado Supreme Court Committee redid the Colgi instructions with great detail, many years-long process. To make modifications to the Colgi instructions is probably also an unwise practice. There were a couple instructions that defense withdrew that I wanted to make sure that we got on the record this morning. The original packet contained an instruction relating to impeachment of a witness with a prior inconsistent statement under 1610-201. It's my understanding specifically that the defense counsel withdrew that intentionally and voluntarily last night at the preliminary conference and has not submitted that today for consideration. There was also discussion at the preliminary conference last night about instruction number 6, which is a limiting instruction. And the outcome of those discussions last night was an agreement by counsel specifically to number 6, in which this was negotiated language that they have agreed to. And both of those things, I think, needed to be on the record here today.
Thank you. And Mr. Moran, you've had more time to look at the instructions you provided in the packet. Anything you want to say?
Yes, sir.
Go ahead.
So I think it probably makes sense as I go through these to number them, that they'll make it.
Well then, all right. Hopefully they're all in the same order. Before we begin, I mean, one of these is, all right, number 8 is something that would have happened days ago at the very start of the trial. So that's number 8.
Okay.
Number 9 is your version of what the elements are and the charges are separate, distinct.
I'll rest on, we prefer that one. I think it better explains it. That's the citation, so I think that's the case.
The next one is number 10, which is, it looks like credibility instruction, which may be a little, not sure if anything's added to it or not. I haven't looked at it very closely.
This tracks the language better in our perspective. We rest on the record there.
Number 11 is presumption of innocence and burden of proof
Based on
and reasonable doubt.
Based on the Pickering decision cited there, and also this is an adaptation of 304 Colgi, or Colgi 304. Colgi states that the what I'll call preamble that it is supposed to serve as a guide. This, I think, improves upon it. We request this can be provided.
Number 12 is a further definition of proof beyond a reasonable doubt, talking about how high a standard it is.
The reason we believe that it should be separated and presented in this way is based on the cases that come below as supporting authority listed here, diluting the beyond a reasonable doubt standard and putting it in with other legal principles as it stands in the instructions that the court's going to provide, unnecessarily dilutes it, and we believe that to be a problem under Colorado Constitution Article 2, Section 15 and 25 in the case of this here.
Defense 13 is an instruction that I gave as instruction number 21. Number 14 is the written questions from the jury, which I gave, I don't know if it's the exact one, but one very similar.
I think so. So this was appropriately considered rejected. And
number 15 is that charges are mere accusations.
based on the adaptation, I think that's necessary of Colgi 303 and the Keenan case. I think there's support for having it read this way. The charge being brought by the state and read by the court gives it more weight in the eyes of a juror than it should, and this motion, or this instruction corrects that misperception, so we'd ask to have that provided.
Number 16 was given as instruction number 10. Number 17 was the credibility by showing previous acts of dishonesty.
I'll withdraw this one.
Number 18 was the confrontation, by a previous statement, which I believe was withdrawn last night.
Yes, sir, withdrawn.
Number 19, uncertainty about any terms used in these instructions. I did give this instruction.
Do you know the number? Not off the top.
I think it's near the end, but no, not off the top of my head.
We discussed this next one.
Hold on, do you want the number?
No, that's all right.
Thank you. So number 20, we talked about earlier, that's the mere presence of the crime scene.
The court did not want further argument on this. I have some, provided briefly.
You know, go ahead.
The lack of unanimity instruction and the prosecution's case that the isolation of Mr. Redwine's home, I think is going to create the possibility in the minds of some jurors that the fact that Dylan's there at some point, Mr. Redwine's there, means that presence is going to be sufficient to make a guilty finding. So without the presence instruction, with no unanimity instruction, with no election, we're creating real problems, and I believe reversible error. So this might minimize the problem a little bit. We'd ask to provide it. There are all of these cases that I think provide support for giving an instruction like this.
All right, number 21 is the mere suspicions are not sufficient not to prove beyond reasonable doubt.
Again, that I think piggybacks really well with defense tendered and it's been rejected. Number 20, so I'll incorporate my argument with respect to the unanimity election, number 20, and the other similar instructions with 21, the defense tendered 21.
22, I don't know where this actually came from. It does talk about unanimity. It talks about every fact essential to prove the element. I believe these are all covered in the elemental instructions for proof beyond reasonable doubt. So
just incorporate the cases cited below it and rest on that. This is an accurate statement of the law.
23 is unanimity instruction that you, I think we've already talked about. 24 is a similar unanimity instruction that we've talked about.
With both defense tendered 24 and 25, I understand the court's rejecting them. We incorporate previous arguments with respect to unanimity election.
All right, 25, I believe I gave about news coverage. I don't know what the number was, but I've talked about it constantly with the jury not paying any attention to it.
Thank you. I would agree that that one was provided.
26 talks about judicially noticed facts, which there were not any. We came close, but there were no judicially noticed facts.
Withdraw that one.
27 is Ms. Redwine's right not to testify, which has been given.
Further language of this one, but I appreciate the court giving this instruction. Thank you.
28 is that talks about law enforcement officials and their credibility, which I'm not giving. Anything you want to say about that?
Yes, based on the testimony that was provided, the theory or the hypothesis provided by the prosecution is that tie always goes to law enforcement, that if there's a problem that is exculpatory, ignore it and only consider what they did for its inculpatory value. That's placing undue weight and giving more credibility just by function of people wearing badges. So we need to ask the courts to accept this. It would put things in their proper context and give the jury arm them with what they need to be able to say that law enforcement officials are witnesses just like the rest. And
law enforcement officers are witnesses, just like the rest that was talked about on Boyd Dyer credibility instruction. I think that clearly covers what we need to cover. 29 is the one about vigorous debate. And don't be coercive or threatening to each other while you're deliberating. Anything you want to say about that?
We just want to make sure that folks are armed with permission to prevent jury misconduct. And if this instruction does that, we ask for the exception.
I'm not going to insult the jury by giving this instruction. Number 30 is the limiting instruction, and a limiting instruction you gave us, but we have a limiting instruction, and I think that was agreed to by the parties yesterday by stipulation.
I would not stipulate to that, Your Honor. We
Okay.
provided the court with a description that we think meets the court's previous orders with respect to the limited purpose for which that evidence could be provided. We are not conceding that the instruction as currently written provides proper guidance, follows the court's previous order, incorporates the law of the case properly. There's an expansion of the 404B limited purpose that has happened very late in the game and right before trial. So we continue to object. We think that evidence of the photograph is absolutely radioactive. The court initially allowed it.
I'll change this. I did this for you yesterday. If you want me just to give the very short, limited instruction, I'll give it. It won't be exactly this one. This is what I provided you yesterday that we talked about. So I'm trying to change that one too.
If the court wants to change it to what we're suggesting, which is
No.
adheres properly to Your Honor's original order that the photographs were being admitted based on the heckling that occurred at Mr. Redwine's house by Denise Hess and Kathy Berry. That was the instrument through which the prosecution sought to admit this. They called it the singular purpose for which they wanted to admit the photograph. Your Honor considered, after lengthy presentations and arguments, I think this issue being revisited in motions to reconsider, the ruling of this court was that evidence could be provided to prove that Mr. Redwine had a violent reaction to confrontation by those photographs. This instruction, or the instruction on this issue, does not track with that limited purpose that became the law of the case, which we relied on in preparing the case. It changed at the 11th hour with limiting instruction that was provided to the jury and objected to at the time. I will acknowledge that we didn't object to the one that was filed or that the court put into ISIS in the weeks leading up to trial. But at the time we objected to it, once we caught it, we would ask the court to return to the law of the case, which was created by Your Honor's order on this issue, and to put the limited purpose to paper, to instruction in the way it was provided by Your Honor in the order from, I think, 2019.
Well, I'm sorry you guys didn't read my orders. I told you what I was going to do. I didn't bring it up more than a year ago. Mr. Johnson, is there something else? This is instruction number 6. So what did I propose?
Yes, Your Honor. I just want to make sure we make a clear record, because last night we did this conference off the record knowing that we would come in. And I agree with the court's characterization. Mr. Moran stipulated this particular jury instruction yesterday. And there is a more simple version the court can give. The single purpose that was granted by the court is motive. The details of how that motive applied were in the narrative of the 404B motion. This could read just simply the limited act and be considered for motive. That would be fine with the people. The only reason we have this more descriptive instruction is because defense counsel throughout the case has wanted some of the additional language, and also because of the conversation yesterday. So if we need to revisit this instruction, I agree with the court, we can simplify it. However, Mr. Moran should not come in here yesterday and stipulate, and today try to preserve a record on an objection that didn't exist at the time this instruction was instructed.
This is why we don't
Hold on.
off the record.
Hold on. Okay, I'm talking now. I'm letting you make your record. I'm letting you do the objection. I was just a little surprised about it. You've made your record. I will give the stock instruction about a limited purpose. If you don't want number 6, that's what I'll do. But you tell me what you want.
This is what I want, is the instruction
Between
that we provided
those
the
two.
court.
Well, the one, which is basically what you gave me. It's from Colgy, but it's I'm going to take it right out of. I'm not sure if it's a different version or not. I guess I will get it. So hang on. Let's go on. I'll do it right now. Off the record.
Judge, I'm sorry. There may be some corrections to the voted form as well, and just some typos.
We'll just get there when we get there.
Okay.
You guys don't have to stand up for me, I'm thinking. So I've just handed you a new proposed number 6, Mr. Moran, which is the straight cold G instruction without the additional paragraph you're asking for, number 30, which just restates what's said above. So which one would you rather have?
I'm only choosing this based on the court denying the one that we've requested. I'm choosing.
I agree.
Okay. And he still objects because it should be one or the other. So what I mean is that this instruction number 6, the one that is not the proposed 6, the last 2 sentences provide 2 bases for which the jury could consider the 404B absolutely radioactive photograph. The first sentence, where Your Honor writes, was to allow the prosecution to attempt to prove that the defendant became violently enraged, tracks with the law of the case, tracks with the ruling made at the time that we argued this, that we presented evidence on this. I think it was a 2019 order. It described the one limited purpose that was outside the forbidden intent, and we lived with it. That changed late. We objected to it once we became aware of it. The jury, I believe, was provided with different instructions on how it could be considered. So the proposed 6 at this point, saying you're instructed you can't consider it except for the purpose I told you about, is going to be problematic because to the extent they remember those instructions, they were different. So original 6 is better, but the last sentence was admitted to allow the prosecution to prove motive creates an issue because the evidence as it stands includes a text message wherein Dylan says to his father, it says to his brother, I want the photograph so I can show Dad who he really is, which is an absolute comment on character, and not being careful in how we instruct the jury on this is allowing the prosecution to get evidence that provides information to forbidden inference in front of the jury. This instruction allows them to consider it. So we're asking the court to adhere tightly to the law of the case. It was considered carefully after evidence provided, arguments made, and that adherence will keep it in a place where the careful consideration that it was given at the time all of that was presented is what gets in front of the jury, doesn't create other issues. So we object to not keeping it to the sentence that starts the first was to allow the prosecution. We prefer the other instructions that more carefully delineate the law of the case, and we base those objections on Colorado Constitution, Article 2, Sections 3, 6, 10, 15, and 25.
So, my question to you was, do you want the shorter version of 6 that it just gave to you, or do you want 6 that's in there? We've already talked about what you want in terms of instruction number 30. Are you telling me you want the number 6 that talks about motive and talks about the photographs, or not? A simple question.
And Judge, I would like.
I'll let you respond.
In this bargain, I will take 6 because of the rejection of the other.
Okay, they're both marked as 6.
One is proposed 6. I'm choosing 6 as marked.
Are you choosing 6 that talks about
The longer
3
one.
paragraphs? Okay, I'm going to mark this as 6B, tendered by the, proposed by the court as part of the record. So, Mr. Johnson, did you want to say something?
Yes, Your Honor, because I know counsel is creating a record, and I want to make sure it's an accurate record, and we'll discuss that later. The people filed a motion for a singular act of other acts of evidence with singular purpose and motive. The court granted that. The interpretation of motive by defense counsel has been to take particular language from that argument to use it. That motion actually explains that Dylan had requested the photograph of Corey and that the violent incident had come afterwards. The limiting instruction applies to what the court has put here, the photograph and the defendant's reaction. To over-particularize the people's argument and characterize it by the defense inaccurate. The court set a deadline for the contemporaneous instruction. Counsel did not make a timely objection. At the time of trial, counsel made an objection that was overruled by the court. The interpretation of motive is different for the parties, but that was the singular purpose to which the court granted it in both people's request and the court's order. I'm fine with 6, but it should be noted that counsel stipulated to this yesterday, changed their mind today, and then it should also be noted that the people are open to a third option that simply says the reason such evidence was submitted to allow the prosecution to attempt to prove motive. The additional language about violence and raised when confronted by others with the photograph that defendants request. The people intend to argue motive generally at closing argument as well, as granted by the court. So we're open to whichever of those 3 options counsel chooses, but we should not be overly specific based on some language from a motion. It should be the court's order that this is allowed to prove motive, period. And parties can argue that that's.
Do you want that change, Mr. Moran?
Which change?
Where we take the longer version that talks about the photographs and simply say that this evidence was admitted in an attempt to prove motive.
No.
Okay. All right, then we're going to give what I previously put in there. So I'm going to have put 6B behind number 30.
I just want to clarify the record that the stipulation, to the extent that it sounded like a stipulation to Mr. Johnson, was not.
I understand that was your position. That's not how I took it. I guess we were all operating late last night and things were confusing. So that's not. I'm not assigning blame to anybody. So, 31 is talking about a unanimous verdict, which we have an instruction about that, but this certainly goes on further, almost inviting a hung jury. So anything that you want to say about that?
That last thing in the world anybody wants is a hung jury, but that is a safeguard that's been built into the American system of justice. Jurors, they can't agree, have to remain with their reasonably staked out positions. This gives them permission to do it. It's an unpleasant reality with all of the work that's been put into it, but it's one for which they need to understand that they are protected, and this instruction to do it would have to be given.
The instructions I'm giving, I think, state the law appropriately. I'm not giving number 31. 32 is your version of the limited instruction, which is, we're not even going to talk about it. I think we've gone through limited instructions, all we're going to.
The only thing I'd have to say about this is we're happy to work on narrowing this down. Since the court would allow it, this is a description of what 404B is about. Again, we ask for it because we believe this evidence to be radioactive. We spent a week inquiring of people whether they could follow the instruction. They said they could. I think that they should be instructed carefully and properly with instruction, or an instruction like it that we work on together that would do that.
Well, we did work on it together yesterday. That's why we came up with what we came up with. I'm not going to give this. It's way too detailed, too long. It's restating evidence that shouldn't be in here, and you are getting number 6 in the packet. Number 33 is the human remains detection dog, which we've already argued about earlier.
I think we've already discussed unconscious bias. I'll rest on the record there.
That's not what I'm, oh, it is. Okay. So that's number 34. Thank you, Mr. Moran. 35 is the bailiff's allowance torture to the jury room, which I gave. Number 36 is a similar, we talked about law enforcement officers. I think the record adequately, I just made a record on this on a previous one.
Incorporate the previous record and the citation.
37 is lessers, and there were stipulations as to what the lessers would be last night, and those have been given. 38 looks like the definition of criminal negligence which was given, and so that's all of them. So those are the instructions tendered. I will change number 7, and other than that, anything else you want to say about instructions, Mr. Moran?
Judge, we have a further question.
I'll take care of it in just a minute. I'll get through Mr. Moran first.
No.
All right. Okay. What is there mistake in the verdict?
Count 2. At the top it says manslaughter committed with criminal negligence.
Hold on a second. Sure. What did I miss?
Free child abuse committed with criminal negligence.
Oh, thank you. I thought, you know what, I did see that last night, and I thought I fixed that.
And then, Judge, the only other note I was going to make is the current coaching instructions put an or between the primary count and the lesser count, just to kind of stress that it's either child abuse knowing the record or child abuse with criminal negligence. My suggestion would be, because child abuse sounds very generic, and then it's again stated child abuse with the mens rea, that we put child abuse knowing the record and then put child abuse with criminal negligence, distinguish them and add an or. And then on the verdict form 1, I would also suggest adding the or. I just think that the jury didn't speak the time frame at the time and check more than one box.
Yeah, I'm not going to make those changes. I think what I said in the bottom covers it, but I will definitely correct the verdict form. Regarding child abuse.
So I think that because it's being provided with knowing or reckless, it's essentially the same thing, same fact, count one, which is a knowing crime. The addition,
Can you let me do one thing at once? Okay, you can bring it up in a minute, but I'm trying to do something else right now. So, Mr. Moran, you also wanted to talk about knowingly and recklessly, I assume, in the child abuse cases?
yes, please. So what we've got here is the last chance to fix this without election, without a requirement of unanimity. We won't know whether the jury decided that Mr. Redwine's conduct was knowing or whether it was reckless. The verdicts will be then contradictory. One being knowing, the other possibly being knowing or possibly reckless. So I would ask the court require the prosecution to choose which one. We're now in a situation where the mens rea will not require unanimity. We also have a situation where the actus reus will not require unanimity. That's why we requested and continue to request election or at least clearing this up with a unanimity requirement provided by instruction. We're doing that under Article 2, Section 1625 of the Colorado Constitution and U.S. constitutional protection.
Well, I'll let Mr. Johnson speak in a second, but I caught that a long time ago. Reckless, however, is basically a lesser included of knowingly. If you act recklessly, you also act knowingly. Therefore, any jurors that only find reckless behavior could find count proven. They could also find, even if some jurors found it to be a knowing action. And so anybody that finds knowing is automatically finding reckless, so you do have knowing. But I don't mind changing it to persons. Say, Mr. Johnson.
Judge, I agree with the court, and here's why. In murder in the second degree, knowingly is applied to causing death. So knowingly is applied to the result. And in child abuse, knowingly or recklessly is applied to the conduct. And that conduct is different than causing the death. So that knowing or recklessly is applied to the conduct causing injury to a child, life or health. So because the mens rea go to different actus reus, there is no conflict. And in child abuse, the result is actually a sentence and cancer, as indicated by the interrogatory and the case law. And so what we have here is a situation where easily, just to use one example, the jury could find that the defendant recklessly caused an injury to the child or knowingly caused an injury to the child, but had a different or similar mens rea in terms of causing death. So they're very different crimes in that one has the mens rea to the actus reus, and one has the mens rea go to the result as well. Because of that, there's no conflict whatsoever in terms of inconsistent verdicts, anything.
Well, he's talking specifically as so with the child abuse statute. And so I'm not sure I quite understand your argument, but my ruling is that I don't see it being a problem because the statute talks about both knowingly or recklessly fits the definition. And if somebody finds knowingly, they've obviously found recklessly.
I agree with that as well, Judge, and I think the statute itself is constitutional and appropriate, and it reads that way in the full jury instructions. And so I agree with the court 100%.
All right.
But if you find recklessly, that's not necessarily knowing.
Correct, but all you have to find is recklessly.
But we stand in our
I understand that. We're
motion for
I understand.
election. And
So we're going to have a short recess then, while we change number 7. I am going to give the instructions 1 through. Where's the number? 26 with the change to 27 and. Or with the change to number 7, excuse me, with the changing the child abuse verdict form. So you guys can do what you want while we take care of that. You don't have to stand up for me because I'm gonna be in and out of here. Becca. This one I need to print also. All right, thank you. All right, Jerry?
Right, we should.
All right, ladies and gentlemen, first of all, I want to apologize to you about the delay. I'm always overly optimistic how fast things will happen. And so you guys got here about an hour, 15 minutes early. So we're ready to proceed now. As you can see, jury number 11 has been excused, will not be participating any further in these proceedings. I wanted to ask if the jury has anybody had any problems being able to follow my admonitions that I think you need to. Okay. Record can reflect there's been no response to that. what we're going to do now is I will read the instructions to you. You have copies of these instructions in your notebooks. You can read along if you want to. You don't have to. After the instructions are read, then we'll start with closing arguments. We'll take a break, a very short break for lunch. I know you guys have already ordered your lunch, so we'll have you eat that. You will be sequestered today, basically. So you need to stay together and or just follow the instructions of Cindy the bailiff. So the record can reflect that Ms. Grigsby does not need to report my reading of these instructions because the instructions themselves are the record. So with that, instruction number 1, members of the jury, the evidence in this case has been completed. In a moment, I will read to you the instructions that contain the rules of law you must apply to reach your verdict. You will have copies of what I read to take with you in the jury room. But first, I want to mention a few things you need to keep in mind when you're discussing this case in the jury room. Until you have returned a verdict, you must not do any research about this case or this kind of case using any source, including dictionaries, reference materials, internet, or other electronic means. You must not communicate in any way with anyone else about this case or this kind of case until you've returned a verdict in court. This includes your family and your friends. If you have a cell phone or other electronic device, you must keep it turned off during your deliberation. It is my job to decide what the rules of law apply to the case. While the attorneys may comment on some of the rules, you must follow the instructions I give you. Even if you disagree with or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all of the law which must be applied. The instructions must be considered together as a whole. During the trial, you received all the evidence that you may properly consider in deciding the case. Your decision must be made by applying the rules of law that I give you to the evidence presented at trial. Remember, you must not be influenced by sympathy, bias, or prejudice in reaching a decision. You should not allow bias or any kind of prejudice based upon gender to influence your decision. If you decide that the prosecution has proved beyond a reasonable doubt that the defendant is guilty, it will be my job to decide what the punishment will be. In making your decision, you must not consider punishment at all. At times during the trial, attorneys made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to legal questions I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during trial, you must not consider it in your deliberations. If I have asked, and I have asked questions of witnesses during the trial, that did not mean I had an opinion about the facts of the case. Finally, you should consider all the evidence in light of your experience in life. Instruction number 2. The charges against the defendant are not evidence. The charge against the defendant is just an accusation. The fact that the defendant has been accused is not evidence the defendant committed any crime. The defendant is charged with committing the crimes of count 1, murder in the second degree, count 2, child abuse resulting in death in LaPlata County, Colorado, on or between November 18, 2012 and November 19, 2012. The defendant has pleaded not guilty. Number 3. In this case, a separate offense is charged against the defendant in each count of the indictment. Each count charges a separate and distinct offense, and the evidence of law applicable to each count should be considered separately, uninfluenced by your decision as to any other count. The fact that you may find the defendant guilty or not guilty of one of the offenses charged should not control your verdict as to any other offense that charged against the defendant. The defendant may be found guilty or not guilty of any one of the offenses charged. Instruction number 4. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after consider all of the evidence, you are then convinced the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense which arises from a fair and rational consideration of all the evidence or lack of evidence in a case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element of the crime has been proven beyond a reasonable doubt, you should find the defendant guilty of that crime. If you find from the evidence the prosecution has failed to prove any one or more of the elements of the crime beyond a reasonable doubt, you should find the defendant not guilty of that crime. Number 5, a fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on first-hand observations of the facts in question. For example, a witness's testimony that she looked out a window and saw snow falling might be offered as direct evidence that it had snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the facts in question. For example, a witness's testimony that she looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. Instruction 6. The court admitted certain evidence for a limited purpose. You are again instructed that you cannot consider that evidence except for the limited purpose I told you about when it was admitted. In this case, one type of such evidence includes testimony and evidence relating to certain photographs and the defendant's reaction when confronted to such photographs. Evidence concerning the photographs were admitted into evidence for two purposes. The first was to allow the prosecution to attempt to prove the defendant became violently enraged when confronted by others with the photographs. The second reason such evidence was admitted to allow the prosecution to attempt to prove motive. Instruction number 7. It is the defense theory of the case that Dylan Redwine left the home of his father on the morning of November 19, 2012, while the father was at work and running errands. Mr. Redwine has no burden to establish how his child died. He is not asserting that the animal attack is the only means by which his son was harmed, only that he did not harm his child. The defense contends the prosecution failed to present sufficient evidence to prove the guilt of the defendant as to the crimes charged and as to the lesser included offenses. Number 8, the defendant has the constitutional right not to testify. His decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. It is not evidence, it does not prove anything, and it must not be considered for any purpose. Instruction number 9. You are the sole judges of credibility of each witness and the weight to be given to the witness's testimony. You should carefully consider all the testimony given and the circumstances under which each witness has testified. For each witness, consider the person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all the facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. Number 10, the number of witnesses testifying for or against a certain fact does not, by itself, prove or disprove the fact. Instruction 11. You are not bound by the testimony of witnesses who have testified as experts. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of the expert's testimony, part of it, or none of it. The weight you give the testimony is entirely your decision. The elements of murder in the second degree as charged in count 1 are 1, that the defendant, 2, in the state of Colorado, at or about the date and place charged, 3, knowingly, 4, caused the death of Dylan Redwine. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the second degree. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the second degree. Instruction number 13. If you are not satisfied beyond a reasonable doubt that Mr. Redwine is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged, if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of second-degree murder, as charged in the information in this case, necessarily includes the lesser offense of criminally negligent homicide. The elements of criminally negligent homicide are that Mr. Redwine, in the state of Colorado, at or about the date and place charged. 3, cause the death of another person. 4, by conduct amounting to criminal negligence. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser included offense, which is necessarily included in the offense charged in the information. The law never imposes upon the defendant, in the criminal case, the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find Mr. Redwine guilty of the offense proven, and you should so state in your verdict. Number 14, the elements of the crime of child abuse are 1, that the defendant, 2, in the state of Colorado, at or about the date and place charged, 3, knowingly or recklessly, 4, caused an injury to the child's the child's life or health, or permitted a child to be unreasonably placed in a situation that posed a threat of injury to the child's life or health. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of child abuse. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of child abuse. Instruction 15. If you are not satisfied beyond a reasonable doubt that Mr. Redwine is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged, if the offense is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of child abuse, as charged in the information in this case, necessarily includes the lesser offense of child abuse committed with criminal negligence. The elements of child abuse committed with criminal negligence are that the defendant, in the state of Colorado, at or about the date and place charged, with criminal negligence. This is incorrect that I have on your verdict form. So the record can reflect that instruction number 15, the court found an error. Element number 3 should state with criminal negligence. Any objection to that change from the parties?
So, Your Honor.
Okay, thank you. Okay, the elements of the crime of child abuse. We go off the record then. The elements of the crime of child abuse committed with criminal negligence are 1, that the defendant, in the state of Colorado, at or about the date and place charged, with criminal negligence, caused an injury to the child's life or health, or permitted the child to be unreasonably placed in a situation that posed a threat of injury to the child's life or health. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of the lesser included offense, which is necessarily included in the offense charged in the information. The law never imposes upon the defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find Mr. Redwine guilty of offense proven and should so state in the verdict. Instruction number 16. If you find the defendant not guilty of child abuse and child abuse committed with criminal negligence, you should disregard this instruction and sign the verdict form to indicate your not guilty verdict. If, however, you find the defendant guilty of child abuse or the lesser included offense of child abuse committed with criminal negligence, you should sign the verdict form to indicate your findings of guilt and answer the following verdict questions on the verdict form. Did the child abuse result in death? Answer, yes or no. The prosecution has the burden to prove beyond a reasonable doubt that the child abuse resulted in death. After considering all the evidence, if you decide the prosecution has met his burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. Instruction number 17. A crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable state of mind. Voluntary act means an act performed consciously as a result of effort or determination. Proof of the voluntary act alone is insufficient to prove that the defendant had the required state of mind. The culpable mental state of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt, either by direct or circumstantial evidence. In this case, the applicable states of mind are explained below. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of such a nature or that such a circumstance exists. A person acts knowingly or willfully with respect to the result of his conduct when he is aware his conduct is practically certain to cause the result. A person acts recklessly when he consciously disregards the substantial and unjustifiable risk that a result will occur or that a circumstance exists. A person acts with criminal negligence when, through a gross deviation of the standard of care that a reasonable person would exercise, he fails to perceive a substantial and unjustifiable risk that a result will occur or that a circumstance exists. Instruction number 18. In this case, certain words and phrases have particular meanings. Accordingly, you are to use the following definitions where these words and phrases appear in the instructions that define crimes, defenses, special rules, and verdict questions. Child means a person under the age of 16 years. Health, as used in instructions 14 and 15, mean both physical and mental well-being. Injury, as used in instructions 14 and 15, means bodily injury, which is physical pain, illness, or any impairment of physical or mental conditions. Number 19, the court necessarily interacts with parties during the trial and rules on legal issues during the trial. You may not draw any negative inferences from the conclusions about the accused's guilt from the differences, if any, that you perceive in the court's treatment of the lawyers for the defense and the prosecution. You must not let yourselves be negatively influenced against the accused in any way by the substance of the judge's rulings or the demeanor and manner in which he makes those rulings. The court has no opinion about the evidence or the accused's guilt that are relevant to your job as jurors. If you perceive that the judge has formed any opinions about the accused, the parties, or the evidence presented in this case, you must not allow it to affect your perception of the accused, parties, or evidence in the case. Instruction 20. If there's been any news coverage of this case, you must completely disregard it. The decision in this case must be based solely upon the evidence presented at trial. Number 21. Mr. Redwine has the right to a public jury trial. Many different people sat in the gallery and observed Mr. Redwine's trial. The jury is instructed that they cannot consider the reactions or statements made by any person in the gallery as evidence, does not prove anything, and must not be considered for any purpose. Instruction 22. During this trial, you are permitted to submit written questions to witnesses. If a particular question was not asked, do not guess why the question was not asked or what the answer might have been. My decision not to ask a question submitted by a juror is not a reflection on the person making it, and you should not attach any significance to the failure to ask the question. By making legal rulings on the admissibility of questions, I did not intend to suggest or express any opinion about the question. My decision whether or not to allow a question is based upon the applicable rules of evidence and other rules of law, not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and the rules of evidence. The fact that certain questions were not asked must not affect your consideration of the evidence in any way. Do not give greater weight to questions or answers to questions that are submitted by yourself or your fellow jurors. In making your decision, you must consider all of the evidence that has been presented. Number 23. Members of the jury, you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or with anyone else at any other time except when all jurors are in the jury room. Instruction 24. If you are uncertain about any term used during the trial or in these instructions, do not consult a dictionary or consult any outside research. Any juror who needs to have any term defined should send out a note, and if possible, the definition will be provided. Number 25, Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to the bailiff, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that under the law the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer the question. Finally, be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case, and must be returned to me when you return the instructions and verdict forms at the end of the case. Instruction 26, I will read to you along with the verdict forms after the conclusion of closing arguments. So with that, the parties will get their opportunity. Make sure your mic is turned on. And Mr. Doherty.
Good morning, Your Honor. Thank you. I just need one moment to the PowerPoint. Good morning. At its core, this is a simple and tragic case. A damaged and deteriorating relationship that turned deadly on November 18th, 2012. And despite the defendant's best efforts to avoid responsibility and accountability, we are here today, and justice is about to come. As Agent Grusing told the defendant, justice is about to come. Back in November 18, 2012, the defendant was an angry and isolated father who was losing contact with the only family member still willing to engage with him. And that family member was only willing to be with him because the court had ordered him to do so. That relationship was coming to an end. And for the defendant, this was incredibly frustrating. He was angry, and we'll go through all the evidence that you've heard over the past 5 weeks. And for Dylan Redwine, he had come to realize that his father, the defendant, was a man. He wasn't just his dad. Dylan had started to realize things about his father, the incredible hatred that he had for his mother and his brother at times, the way he acted, the things he liked, and their relationship had deteriorated incredibly over the past couple months before the murder took place. Dylan was no longer simply an adoring young boy who just wanted to be with his parents. He came to recognize that his parents were people. And he came to recognize the person that the defendant was in his life. And for the defendant, the last family member who had any contact with him was starting to realize why every other family member had broken off that contact with the defendant. That's what's happening in the time from September through November of 2012. We are here today because this man killed Dylan Redwine. And it's a murder trial. So we spent a lot of time talking about the evidence that proves him guilty beyond a reasonable doubt. Let's talk for a moment about Dylan. He was killed when he was 13 years old. Let us not forget that when we talk about luminol and phenolphthalein and human trace and DNA and human brain dogs, we're talking about a 13-year-old boy whose life was ended. Let us not forget when we talk about sharp force injuries to the right zygomatic arch of the partial cranium, that we're talking about the head of Dylan Redwine. Let us not forget when we look at phone logs and cell records, text messages, that we're actually talking about the last words of a 13-year-old boy who this defendant killed on November 18th, 2012. Because of what the defendant did, this world will never know Dylan Redwine beyond that day. We'll never know the impact that he would have had on this world today. His high school years, college, a future, a family of his own, all those things were robbed because of that guy. We'll never know Behind the 5 weeks of trial that we've spent here together and the mountain of evidence against this defendant is the life of a 13-year-old boy that was robbed by this defendant on November 18th, 2012. We have learned during this trial, while listening to the evidence against the defendant, a fair amount about Dylan. He was a young boy. He was happy. He was engaging. He lit up the room. The witnesses talked about the impact he had on their lives. Everyone who took the stand and swore to tell you the truth told you about Dylan and the positive impact he had on them. Amanda Saxton told you Dylan was feisty, and he would stand up and fight for those that he loved and for what he believed was right. And that Dylan loved his family and was severing the relationship with the defendant because of the defendant's incredibly hateful conduct, his mother and his brother, as well as the photographs and the deteriorating relationship between the defendant and Dylan. Even for Dylan, a loving boy at heart, this relationship was severing. It was slicing and it was cutting and it was coming to an end. Because the defendant's words and his deeds had pushed this loving young boy to a point where Dylan no longer wanted to have any contact with the defendant. And the only reason that he had contact with the defendant was because the court ordered him to do so. I'm sorry, Your Honor. Dylan Redwine was beloved by his family. And like many 13-year-old kids, he had become very close with his friends, old and new. And he stayed in constant contact with them through his phone, email, text, and social media, and left a trail of breadcrumbs for us to follow to this defendant. Like many teenagers at age 13, Dylan had connected with his friends at a level that he wanted to maintain. And we've seen throughout this trial the impact that Dylan's loss had on his family. We've seen Dylan's family cry when they see pictures, and cry when they see possessions, and cry when they remember Dylan. And we've seen his family do that. And by family, I should be clear, I'm talking about Elaine Hall and Corey Redwine. We've seen how much this still impacts them to this day, the loss of Dylan. They look to his photos for his memories. We look to the evidence to hold his killer accountable today. For Dylan's friends, they lost someone far too young, who they are incredibly close to. And when a young person loses someone in their life that young, that memory can either become an inspiration for them to live their best lives or a burden they never overcome. And you saw the burden that each one of them took to the stand, the love they have for Dylan, the impact that he had on their lives, that they still carry with them to this day, from when the defendant ended his life in November of 2012. For the friends and family of Dylan Redwine, all they have left are the memories. But we also have the evidence to hold this man accountable for what he did to Dylan Redwine on November 18th, 2012. The disappearance and murder of Dylan had such an incredibly profound impact on his family, his friends, and this community, ladies and gentlemen. And for the witnesses who testified under oath, 9 years have passed since Dylan was killed. And lives have changed, some because of the murder. It's clearly hurt them in a deep way. But for everyone involved in this case, everyone who came from this community to help with this case, they did so to answer the call for help for Dylan. And it may be difficult It may be difficult for some to think about how could a father kill his own son? How does a father kill his son? And deny the world Dylan Redwine? Well, it's a story that's been told for years, for centuries, in Greek mythology, the Bible, and for too many days and too many communities across the nation. And in this community on November 18th, 2012. Because the defendant killed his son because they were in a deteriorating, damaged relationship that turned deadly on November 18th, 2012. At its core, this is a simple and tragic case. Who was the last person seen with Dylan Redwine, a 13-year-old boy? Who was with Dylan at the very moment that Dylan was never heard from again? The answer to both those questions is the defendant, ladies and gentlemen, because he knowingly killed Dylan on November 18th, 2012, when he was the only person with access to Dylan, and the last person Dylan was with when he ever communicated with anyone in the entire world. Who had the opportunity and reason to hurt Dylan? And who had Dylan's blood in his house? The answer to both those questions is the same, and it's this man. He had the opportunity, he had the reason, and he ends up with the blood in his house. Who had the smell of a dead body in the same room and outside the home? Who had the smell of a dead body on his clothes and in his truck? And then, after the disappearance of Dylan, after he dumped his son's body on the mountainside, whose behavior was incredibly evasive, suspicious, and misleading, not just to law enforcement, not just to the FBI, not just to search and rescue, not just to the friends and family, to you. And we're going to go through what he did in the hours, days, and weeks that followed Dylan's disappearance, because that demonstrates that this is a murder. The defendant knowingly killed Dylan and then did everything he could to avoid responsibility. Whose house was very close to where the remains were found? That's the defendant. And what do the remains tell us? Two things. First, some of Dylan's belongings are gone from the remain site. The only person with reason to do that is the defendant, who doesn't want Dylan's body identified or connected to him. And what is Dylan's remains, which the defendant did his best to dispose of, and he almost succeeded. But what do the remains tell us about what the defendant did on November 18th, 2012? What does it say when you see blunt force trauma and sharp force injuries to the right zygomatic arch of the partial cranium, Dylan's head? The defendant knowingly killed Dylan Redwine, ladies and gentlemen, and that is why we are here. And when you look at each one of these questions, it's a simple and tragic case. Occam's razor. You slice and cut away the things that are unreasonable and look at what the evidence shows you. The defendant's going to argue, as he has throughout the trial, that all these things are simply a coincidence. A wise man once said, coincidences are the universe's way of pointing you to truth. These are not simply a string of random coincidences. Every question is answered the same. The defendant. He killed Dylan Redwine on November 18th, 2012, ladies and gentlemen. Let's break down each one of those, and I'm going to go over the evidence in support of each one of those factors. Each one of those pieces of evidence that proves the defendant guilty of murder in the second degree and child abuse resulting in death. The defendant's the last person seen with Dylan. He picked up Dylan from the airport on November 18th, 2012 at around 5:45 p.m. Less than 5 hours later, in a fairly isolated area nearby Aceto Lake, Dylan is never heard from again and never seen again. When Dylan arrives at the airport, think about that moment. Because when he arrives at the airport, he does not want to be with the defendant. He's expressed that to his friends. his friends in Colorado Springs who you heard from, Joe Ceballos, Adam Harvey, Kristen Baird, all talked about how desperately Dylan did not want to come here, did not want to be with this man, how he had fear in his eyes, he was scared, and did not want to go. Dylan had communicated with his friends that he did not want to be with the defendant. Dylan had communicated with his family that he did not want to visit the defendant. He had told his mom, his brother, his stepfather, I do not want to go. So much so that his mom called the attorney, Amber Harrison, and said, is there any way we can keep Dylan from having to travel there? Does Dylan really have to go? But Dylan had to go because the court ordered him to do so. Dylan had told his stepdad, Mike Hall, that he did not want to go. And he told him about the reasons why he did not want to go. And Mike Hall said, you have to go and just hang out with your friends when you get there. Make plans with your friends when you get there. You can imagine how troubling it was for Dylan at age 13 that he had to go spend time alone in the Vallecito house with the defendant. Given the lead up, the history, the photographs, and the things you've learned about throughout the course of this trial, the 3 months leading up to it in which Dylan never spoke to the defendant, he wanted to break all contact and he wanted that relationship severed. It's not surprising that all those ongoing events in their relationship would lead Dylan to want to avoid this visit at all costs. Told his friends and his family that he did not want to go. It also, in essence, told the defendant. He certainly hadn't been hiding his feelings, because in September, when the court asked Dylan, who do you want to live with? And Dylan said, my mom. After that, after the pictures, after the text messages, after the court hearing, Dylan broke off contact with the defendant. And by September 2012, Dylan is no longer texting or calling or returning any of the messages that he gets from the defendant. And you see that in Exhibit 480, where the defendant sends 11 text messages to Dylan over the span of nearly 2 months, and not a single response from Dylan. And the only responses before that were with regards to the debit card, which we'll come back to. But otherwise, Dylan has severed this relationship. He is done. He does not want to have contact with the defendant. The defendant's fully aware of it, and he's angry about it and frustrated about it. And you see that in Exhibit 8, where the defendant emails Elaine, and he copies his attorney on it. This is Sunday, November 11th, 2012. A week from this date, Dylan will be dead. By now, you should have received Dylan's flight itinerary. As you know, Dylan has failed to respond to all my communication attempts, so I'll have to rely on you to inform him of his travel. Also, since you have failed to address any support issues you may have, I expect all his needs are being addressed. So all the monies in his personal account are not needed. XXX. We'll talk more about the personal account in a little while, but this email from the defendant confirms that 1 week before the murder, he knows his son wants nothing to do with him. He wants to break off all contact. So think for a moment about Dylan arriving at the airport. Dylan does not want to be there. He knows it, and he's frustrated and obviously angry to the point where he's talking about taking Dylan's personal money out of Dylan's own bank account. And he's emailing Elaine, the mother, and copying the attorney because he's going to enforce that court order and force Dylan to visit. What you don't see there is a, hey, why doesn't Dylan want to come? Hey, I haven't heard from Dylan. Is everything okay? Hey, can you set up a time for me to talk to Dylan? I want to sort out what's going on. He hasn't responded to me. It's a, he's coming. Here's my attorney's email address. And by the way, I might take the money out of his personal account. That's the state of their relationship on November 18th, 2012, when Dylan heads to the airport and flies to Durango. Which is why when the defendant goes to pick up his son at the airport, he knows how frustrated Dylan is and how much Dylan doesn't want to be with him, and we know how frustrated he becomes. And from the very beginning, we see that. The defendant talks with Agent Grusing about how Dylan did not want to be there and was standoffish. Dylan had made his feelings perfectly clear. From the moment they go to the airport, leave the airport and go to Walmart, and Ms. Burton, who's been working at Walmart for over 20 years and looks at these security videos all the time, it's part of her job. And on cross-examination, on a question from the defense, said he just looked like he did not want to be there. They spent 41 minutes in Walmart. They're barely together. And when they are together, the evidence will show they're not getting along. They're barely together in Walmart. They haven't seen each other in over 2.5 months. This is the relationship that's going to turn deadly in about 5 hours, ladies and gentlemen. Dylan does not want to be there, and it's why he does everything he can to avoid his father, including having reached out to Ryan Nava earlier that day. He reaches out to Ryan at 12:05. Can I stay with you tonight? He hasn't even arrived in Durango, and he's trying to make a plan so he doesn't have to be with the defendant. Ryan says, if we get back in time, yeah, and then follows up with, you can. We'll be home around 8 or 9 p.m. In one of the few interactions that we see between the defendant and Dylan in Walmart, we now know from this text message that Dylan's asking the defendant, can I stay with Ryan Nava tonight? Which obviously means, I don't want to stay with you. And the defendant says, no. And Dylan sends a message from Walmart at 6:57, can't come, sorry, I'll hang tomorrow. And if you watch the Walmart video, you see at 6:57, they're walking down the aisle together talking at that point. That's where the defendant's telling Dylan, no, you can't stay with your friend. It's confirmed by Ryan saying, did your dad say no? Dylan says, yeah. Can I come over early, like 6:30 early tomorrow? He's just arrived in Durango. He hasn't seen the defendant in 2.5 months. And he's saying, how quickly can I get out of this house? And the defendant's fully aware of that. And we're going to talk more about the impact that it had on the defendant. As he explained to FBI agent Grusing, it led to tension. It made the defendant angry. Dylan wants to be out of that house as quickly as possible. So he's texting Ryan Nava at about 6:30 in the morning, coming to Ryan's house and being with Ryan instead of being with the defendant. And we know after this text exchange from Walmart that the defendant wants to go have a sit-down dinner where he can eat and drink with Dylan. And Dylan says, no, I'd rather just get takeout from McDonald's. So they go to the drive-thru at McDonald's, and Dylan is never seen again. He goes with the defendant to the defendant's house in a fairly isolated area, and he's with the one person that he does not want to be with. And it's obvious to the defendant that Dylan doesn't want to be there. The defendant himself confirmed the state of affairs when he spoke with the FBI, and he told Agent Grusing about how Dylan was standoffish and wanted to go to Ryan Nava's, and the defendant denied the request. He said, you can't go, and that Dylan was upset by that. So Dylan is now left with having to spend the night in his house. And he says to Ryan about the 6:30 a.m. visit, you better let me in. And Ryan Nava responds, I will. Dylan says, I call your all day if you don't. And instead, he never called Ryan Nava again. It was the last time that Dylan would ever have an opportunity to call Ryan Nava. And the next day, when Dylan so desperately wants to see Ryan that he's going to call his ass all day, if he has to, he doesn't call a single time because he's dead. And Ryan will never get another phone call from Dylan all these years and all these years to come because of this man. The defendant confirmed all this to Agent Grusing and talked about how there was tension about this. And Dylan, and this is an important fact we'll talk about later, that Dylan told the defendant he was going to meet Ryan Nava at 6:30 the next morning. Do you remember that? Going to meet Ryan Nava at 6:30 the next morning, and the defendant was going to drive him to Ryan Nava's house so he could be there for the 6:30 a.m. meeting that they set. And we're going to be coming back to that in a few minutes, ladies and gentlemen. So Dylan is last seen alive with the defendant. They leave the Walmart, they go home to the defendant's isolated home out by Seal Lake, but they're not alone in the car. Along with them in that ride is tension and anger with them. And the defendant's the last one to see Dylan alive. But there's more. Because we know the defendant doesn't drop Dylan off anywhere on the way, and they end up back at the house in Vallecito. In just a couple hours, Dylan will never be heard from again. He's in that house in Vallecito, and we have a young boy, Dylan, who's on Facebook, text message, his phone all the time. And he leaves that trail of breadcrumbs for us to follow so that justice will come. His friends testified that Dylan responds to their text immediately, all the time. And you see it in the exhibits that have been entered into evidence. He's in regular contact with his mom, Elaine, since landing in Durango. They're talking, and you can look at the times. It's 1 or 2 minute responses. Boom, 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 boom. The whole day until Dylan's life is ended. He's in repeated contact with his friends since landing in Durango. And he's texting from the defendant's house throughout that evening. We have the Wi-Fi from the defendant's house. So as the defense continues to assert maybe there wasn't a good enough signal, you have the text messages and the iPod messages that Dylan is sending to his friends that evening from the defendant's house. The text with Amanda Saxton. Dylan, I think you're talking about something. They're doing this flirtatious conversation back and forth. What do you think I'm talking about? Nothing, says Dylan. Amanda says, no, tell me, kitty. Her nickname for Dylan. He says, sissy, sissy, sissy. And she responds, and then Dylan says, is pimpin', which is a phrase that he had started using. That's the last communication that Dylan has with anyone in the entire world. And when he sends it, he's sitting in a room with this guy. With tension and anger. That's the last message he ever sent. And Amanda Saxton testified, as to Dylan's other friends, that he wouldn't have dropped off like this. He would have sent something else after this. He would have said, I have to go, or where'd you go, or good night. He wouldn't have dropped off like this, with this being the last message he ever sends. And we know that at 9:56 p.m., when he's alone with the defendant in that living room, as the defendant admitted to Agent Grusing, Dylan's phone goes off. All communication ceases. Dylan is off the grid because his life is over. So let's consider these facts, ladies and gentlemen. And the fact that really helps us understand what's going on in that living room is Dylan's trail of communication. It really is the breadcrumb trail that we could follow to what happened. Because at 9:37 p.m., Dylan has no further contact with anyone. No text at all with anyone after that. He's texting throughout the evening before going radio silent at 9:37 p.m. So he's not just last seen with the defendant. The defendant is with Dylan when Dylan is never heard from again. And there's only one person in the room with him when that happens, and it's the defendant. Now, the defendant makes your job somewhat easier, and he makes a mistake when he says Dylan is alive and awake that night and alive and awake the next morning. Because the facts, the evidence, and common sense prove that's impossible. First, you look at Dylan's use of phones and social media. This was a kid, like many teenagers, on the phone and social media all the time. He's very connected to his friends. He responds immediately. He's in frequent contact with them and with his family. He doesn't respond to his friends that night. He doesn't respond to his mom, who asks if he's doing okay. He also doesn't check Facebook, which he checks every day. He doesn't check it late that night, and he never checks it again. And on November 19th, his Facebook page shows 0 activity. Dylan is gone. He is gone. At the same time, he's in the living room with this man who's angry with him about a damaged and deteriorating relationship. They were texting, him and his mom, on the 18th, 7:03 p.m. Your dad gets you, son? Yes. I miss you already, but try and have fun. How's it going, son? You okay? No response to this text. That's at 8:09 p.m. How you doing, son? I miss you. That's on November 19th. 11:19, his friends start looking for him. We have text messages going from Ryan Nava to Dylan, 6:46 a.m. Where are you? And the importance of this text message, ladies and gentlemen, is that at 6:46 a.m., if this defendant's telling the truth, which he is not, Dylan is awake and in the house and already 16 minutes late meeting up with his friend. Because the defendant tells Elaine and also tells the FBI agent that he spoke with Dylan that morning. So where's the phone call or the text to Ryan Nava saying, hey, I'm going to be late? 7:30. Ryan Nava's now calling Dylan to say, where are you? You're supposed to be here at 6:30. No answer. Come to Nando's. Dude, your dad's looking for you at 4:12 p.m. Are you all right, dude? 7:59. You need to call somebody, anybody, ASAP. We're all worried about you. Your mom called, and she's worried, bro. 8 o'clock. Seriously, when you get the message, call someone. The key piece here for you is that the defendant has told us that Dylan is alive and awake in the morning. It makes your job easier. Because you realize if he was alive and awake in the morning, his day looks much different. Because the defendant says he's leaving the house at 7:30 in the morning. That's the time he says he left the house. That's the time that Ryan Nava is calling to say, where are you? And text him. If the defendant's story were true, he would be responding to Ryan. He'd be responding to his mom. He'd be up and checking Facebook. And the defendant gives no explanation as to why Dylan has suddenly stopped using his phone, his iPod, and his life to communicate with his friends. And if the defendant's story were true about the morning, why would Dylan not have taken the ride to Ryan Nava's house? Why would the defendant not tell him, text or call Ryan, we're supposed to be over there at 6:30, we're already late? And why is Dylan not answering the 7:30 in the morning call, ladies and gentlemen? Dylan were alive on the morning of November 19th, and you know a lot about Dylan Redwine. We never had the privilege of meeting him, but you know a lot about him. And you know how much contact he has with his friends, and you know how much he communicates with them, and you know how much he uses his phone. And he has gone completely dark by this time. If he were actually alive on the morning of the 19th, like this guy wants you to believe, he would have been in touch with Ryan. He would have been at Ryan's house. He would have texted Ryan or called Ryan. He would have responded to his mom. He would have been on Facebook. And instead, Dylan is never heard from again. So the defendant makes your job easier when he doesn't tell the truth to law enforcement and the FBI. And he said Dylan is alive and awake and talking to him on the morning of November 19th. He actually makes your job a little easier. We have the trail of breadcrumbs, and that trail has come to a cold end by the time the sun rises on November 19th. And so is Dylan's life. Dylan is dead by this time. And that's why he has gone completely radio silent, off the grid, dark. Because this defendant ended his life. And then he would begin doing everything he could to avoid this day, and to avoid responsibility, and to avoid the time that a jury would be asked to hold him accountable for what he did to Dylan. He's the last person seen with Dylan, and he's with Dylan when Dylan is never heard from again. But there's more. The defendant had the opportunity and the reason to hurt Dylan. The opportunity part is easy. The two of them are alone in a house, together, at the end of a 20-mile road that comes to a dead end. It's an isolated area. There is no one else there. No one drives by the house. Very few people are staying in the area, and the two of them are alone. Two people alone in the house, one of them is killed. This isn't like a Clue mystery game or a movie like Knives Out, where you have 10 people living in a dark mansion at night, and there's a bunch of people who want one person dead, and that person ends up dead, and it's a mystery. If this were Clue, or a movie like Knives Out, it wouldn't be very long. There's two people in a room, and one person ends up killed. That person is the murderer. It's a simple and tragic story. And not at all like a board game, and not at all like a movie in terms of the consequences and what happened to Dylan. But he had every opportunity to do this. And he also had reasons to do it. We told you in jury selection that you'd hear comments and testimony, and you have, about a time in Dylan's life where he loved his dad and said things like that and hung out with his dad and went on trips. We told you that from the very beginning. And that had been their past relationship. But when you look at the timeline, by the August trip, Corey and Dylan's mom, Elaine, are now in an incredibly tumultuous and contentious relationship with the defendant. And the defendant's very angry with them, has no contact with them, and the relationships have gone south. On the August trip, where Dylan's with his father, they're in a hotel. Once again, the defendant is talking and criticizing Elaine and Corey. This upsets Dylan. He is going to stand up for those he loves. He doesn't like when this defendant continues to badmouth his mom and his brother. He calls Corey, and Corey steps out of the movie theater, and Dylan is making a request. And you can see that request in Exhibit 482. Hey, send me those poop pics of Papa. He gave a speech about you guys being a bad example, and I want to show him what he really is. That text is sent from Dylan to Corey at 10:35. You got him yet? You got him yet? And then at 11:19, hey, send me those poop pics of Papa, because he gave a speech about you guys being a bad example, and I want to show him what he really is. Dylan then sends that message again, 11:19, 11:21, 11:22, 11:24, 11:24 again, and 11:27. And Corey Redwine doesn't want to send them to Dylan, because he knows that Dylan is going to use them to hit the defendant's emotional target. So Corey says, hey, my email got wiped. I've lost the photos. But Dylan had already seen them. He saw what they were about. And you know from Agent Grusing that the defendant then goes on Dylan's phone and sees what this is about. This was a deteriorating and damaged relationship by August. They have a fierce argument. Dylan leaves the hotel room. And after this, in the September custody hearing, Dylan asked to be with his mother and further rejects the defendant. That same day, and it's no coincidence it's the same day, when the judge grants primary custody to Elaine Hall, the very same day, the defendant books this trip that brings us here today. It's the act of an angry man who's going to hold that court order in place. And Dylan then rejects his father further, not returning his text, ignoring his calls, and trying to get out of the court-ordered visit in November. It's no coincidence, ladies and gentlemen, that the last person seen with Dylan, the last person with Dylan, when he's last heard from, also happens to be alone and angry with Dylan. It is a broken and toxic relationship, not just with Dylan, but also with the rest of the family. And in some ways, this is about more than the anger the defendant has at Dylan. And what he does is more than just anger at Dylan. It is rage at the family situation. You see it here in the timeline. So when we hear from people about a year earlier, they were hanging out and having a nice time, that's great. But what matters is the timeline before this happens, because that tells you where they were and how their relationship was working when Dylan was killed. And Joseph Bios testified, his good friend from Colorado Springs, Dylan had fear in his eyes. Kristen Baird said Dylan was scared and did not want to go. And we were hugging him. It turned out to be the last time they would ever have a chance to hug Dylan. And the defendant was not taking this rejection very well. And again, it's about more than just Dylan. And perhaps you were struck by this as well. But he's so bent on forcing the relationship with Dylan and enforcing that court order that's going to require Dylan to come here. And Dylan does not want to come. He doesn't want to be with him anymore. So his mom calls Amber Harrison. And perhaps she was struck by the fact that the attorney takes the stand. And she starts crying. And you suddenly realize she too feels guilt. Because she told Elaine, you have to put him on the plane, or you're going to be held in contempt of court. And the attorney is crying because she realized that she was just doing her job and giving the right advice, but dooming Dylan, dooming him. Because after he arrived, 5 hours later, he is dead. So when Amber Harrison takes the stand, she cries because she realizes, through no fault of hers at all, that Dylan ended up with the defendant, serving a sentence that he did not want to serve, that the court required him to serve, in being with this man. And when you think about some of the family dynamics here, ladies and gentlemen, the anger really is about so much more than just Dylan. And you see that. You see that when Dylan goes missing, he's gone. The last place he's seen is with the defendant in the defendant's house. And the defendant tells the FBI, I think it's probably because of Elaine. He may have ran away because of Elaine. And Agent Grusing says, what are you talking about? He left Elaine and he's here now. Why would he run away from her when he's here? Even in their opening statement to you, they had a slide up here with Elaine's picture. And they said, she's the main generator as to why we're here. What are we talking about? She was hundreds of miles away. Her alibi checked out. Her son is killed. And even here at trial, the defendant's blaming her. She's the main generator. Her son was killed. This case, for 9 years, and the relationship building up to Dylan's murder was about more than just the anger that the defendant had towards Dylan and the rage he acted with that night. The whole family dynamic. You might think you're reading like Shakespearean work, where the father is isolated, alone, and angry, and every family member has left, except the adorable, cute boy who's left behind because he has to be there pursuant to the court order. And then the defendant acts out and kills that boy because of his anger towards that boy and everyone else. But unlike Shakespeare, this is no fiction. And in real life, we never get to meet Dylan Redwine, ladies and gentlemen, because he's dead on November 18th, 2012. Because upon arriving, the defendant gets more rejection from Dylan. At the airport, at Walmart, Ryan Nava the phone call, being on the phone, not wanting to go to dinner with his dad, wanting to go to McDonald's. By the defendant's own admission to the FBI, there's tension in the house. What rejection happened in the house that was finally too much for the defendant? What did Dylan say? What did Dylan do that finally infuriated him? Like many murder cases, we'll never know because the victim is dead. And most murder cases don't happen in public. But without the victim, we're left with the evidence, the mountain of evidence against this man. We know that Dylan's in the living room, and Dylan's the kind of kid who's going to stand up for his mom, stand up for his brother. We know Dylan knows about the poop pics, as he calls them. I could show them to you, but you remember them, ladies and gentlemen. Think about the impact they had on his 13-year-old son and how desperately Dylan wanted to use them during that August fight. Do you think it would have taken much for Dylan to use them in November, to bring them up, to talk about them? So perhaps it's the poop pics. I can't tell you what was going on in his mind that night. Perhaps Dylan just said, F you. Perhaps Dylan cursed at him. That's not very, very speculative.
You'll be allowed to comment on the lack of evidence when you argue, Mr. Bogan. Go ahead.
Thank you, Your Honor. But we know by the defendant's own admission that there's tension and anger that night. And we know from Dylan's comments to his friends, family, that he does not want to be there. It would not have taken much. And you're allowed to consider the pictures of the defendant with the feces smeared on the diaper and him wearing the women's lingerie and eating the feces out of the diaper as evidence of the deteriorating relationship as well as a possible motive. But whether it was the diaper pictures, which had obviously an impact on Dylan and Corey, both were terribly disturbed by seeing their dad like that, or whether it was Dylan just saying something. The defendant had had enough. And we know with the pictures what that meant in their lives. So when it comes to the pictures, Corey Redwine took the stand and testified under oath. And he told you Dylan lost all reason to look up to his father on that day, the day they found the pictures on the computer. We know the defendant becomes violently enraged when someone confronts him with the pictures. We know that. And we know that because Kathy Berry went to the defendant's house and in a colorful string of profanities also pointed out to the defendant that she was aware of the pictures. And the defense introduced an exhibit and read part of the exhibit to you. It's under Defense 1900. What's really interesting is what you see in the rest of this transcript. So this is a transcript of a phone call with Kathy Berry, where she's talking about the log incident, where she called the defendant an S-eater, and the defendant exploded. And she says, in Defense Exhibit 1900, it was frightening. The look on his face, you know, it's like, that's just like you just saw this snap of rage, which, you know, I mean, who knows? I mean, what if Dylan did say something to him about those pictures? That's something that frightens me. That is, what if he did? I saw a side of him that really gets to him. You mentioned that, and man, he is a different man. He is a different man. This transcript was introduced by the defense for another part of the conversation with Ms. Berry. You should take a look at Defendant's 1900. It's a different side of that man. We know Dylan, from Elaine Hall's testimony, is disgusted, ashamed, and willing to use those pictures to defend his mom and brother. We know that last part from all those text messages. So whatever the spark, we know what happened that night. We also know how much...
Or the vote legitimate? No, they are not. So that's what you and the vote, I'm not arguing, is that it's my face. or what I'm arguing is the fact that they were fabricated, because it was actually, I believe that Elaine and Corey were coming into my house from an Israelite, going through my personal belongings when I traveled out of town. Because I have a U.S. interest on there, and Corey did not get into that. I found all kinds of things missing. And I came up with a scheme that had to be so outrageous that they could not talk about it. And that's exactly what I got out of that. Did I ever intend to be sitting here on your show having this conversation with you or them? Absolutely not.
They're saying they broke into your house and fabricated the picture.
I fabricated pictures, left them available.
That's obviously not true, right? That he fabricated those pictures, you can look at them. There's no fabrication there. But he's willing to go on Dr. Phil and tell that story because of how badly he wants to hide this part of himself. You can imagine the reaction if his 13-year-old son says something about it to him. A 13-year-old son who is ready and willing and anxious to do so in August. Whatever started it, we know Dylan will stand up for his mom and for Corey. And we see that in that exhibit 482, where he's asking Corey for those pictures so he could stand up and fight for his family. Whatever it was, it just needed a spark because of how much their relationship had deteriorated. Whether it's a comment about the poop pictures, whether it's saying something else to the defendant, all it took was a spark. And that's what happened on November 18th, 2012. And that's why Dylan goes off the grid when he's in that living room. But there's more than that. It's more than deteriorating relationship before and what happened in the living room on November 18th, 2012, and all the evidence that comes after. But it's also everything the defendant does to cover it up and to avoid responsibility for what he did. We know that Dylan's murder was not caused by an accident. We know Dylan's murder was not caused by a bear because of all the evidence that comes before and everything that he did after. And all it took was a spark for this man to end Dylan's life, ladies and gentlemen. We also know that we have Dylan's blood in the same room. So at 9:37 p.m., we know the defendant and Dylan are in the living room. Dylan never has communication with anybody else again in the entire universe. And from the evidence in the case, we also know that's where the defendant killed Dylan. The defendant says they were spending time in the living room. There was tension. There was anger. In the living room, we have floors that were recently installed and purchased after the fire, and also new furniture that was purchased after the fire. And Dylan had only been in the house on a few occasions between the floors and the furniture being purchased and the time when he was killed. And November 18th, 2012 would be his last time in that house. The living room is relatively new. You have the certificate of occupancy in evidence from April of 2011. It shows that the defendant was not living in the house for a period of time because of a fire. And the fire had required major renovations, including the new floor and the new furniture. And I know how close you paid attention throughout this trial, so you likely remember this. But the defense expert's on the stand, Richard Eichenblum, and he's talking about evidence in the living room. He's talking about the crime scene. He's trying to give you his expert opinion. And Mr. Johnson says to him, when was the fire? And Dr. Eichenblum says, what fire? And Mr. Johnson says, well, when did you get this? When did he get the new furniture? What new furniture? How about the new floors? When did he get the new floors? And the defendant's expert says, that would be relevant information. Heck, yes, would be relevant information, because if you're an expert, as Dr. Eichenblum is, and like the people's witnesses, you know that the amount of time someone spends in a house will factor into the analysis of why you're finding the person's blood there. We also know this from all the work that CDI did at the scene. As the defense expert says, luminol is especially helpful when the suspect cleans up. Luminol tests positive in the house, 5 different locations. Phenolphthalein, as the defense expert said, can rule out false positives. They also use phenolphthalein. And the way hemotrace The only false positives with hemotrace are higher level primates, such as orangutans and chimps, and also ferrets. So we have 5 blood samples tested 3 different ways, positive. And the defense expert, upon hearing that, says CBI used a good procedure. So let's talk about CBI today. We have Mr. Clayton, who's been in over 1,000 different crime scenes. And he tells you how, well, you already know this, how unusual it is to find blood cleaned up throughout a living room, particularly a living room with a new floor and new furniture. And the way the blood was spread out, there's a broad area, reflects to Mr. Clayton, who's an expert, that there was movement. Also, the blood being under the carpet, but not on the carpet, shows that someone has made efforts to clean it up. Throughout the trial, the defense fought hard to deny that it's the defendant's blood. The defense challenged every single witness on whether this is Dylan's blood or not. Think about the lengthy cross-examinations about whether it's Dylan's blood in the living room or not. They challenged the validity of the test, even the one that only has false positives when it's a chimp. And in a murder case, of course, it makes sense for the defense to say the blood is not that of the victim. That makes sense, right? You would do that. Except it's too little too late, because when the evidence recovery team truck rolled up on November 29th, the defendant blurted out for the first time that Dylan was dripping blood in the living room. So as we continue to hear evidence throughout this trial about whether that blood is Dylan's or not, keep in mind that the defendant himself tells the FBI it is Dylan's blood. Now,
The jury will remember what the evidence is in their collective memories. You can comment on, I think it's a fair comment, you'll be able to do the same. Go ahead.
so you may remember that the defendant tells 3 false versions before that. It's a whole bunch of people, but ends up telling the FBI on November 29th when the truck pulls up, Dylan was dripping blood on the floor. So as we go through this trial, and as we talk about whether it's Dylan's blood or not, I would ask you to remember that the defendant has told us, after giving multiple false versions, the defendant has told you Dylan was bleeding on the floor. And we'll talk about that more in a little while. But we know it's Dylan's blood from the room. Remember, as Agent Grusing said, when you hear a statement by a suspect, look for vague statements or omissions. I would suggest to you that when the defendant leaves out any detail or mention of how he cleaned up the blood, that's that kind of vague statement. That's that kind of omission that Agent Grusing says to look out for. He says Dylan's dripping blood on the floor from an ulcer. That's his first version, or first version of the third statement. He never says how he cleaned it up, because he doesn't want to detail what he did to clean up a murder scene. We had a lot of discussion about whether blood can be cleaned up or not. Based on the defendant's statement, we know it was cleaned up. So it's not visible to the naked eye when CBI comes in pursuant to the court-ordered search warrant. And unlike what you've heard during this trial, the defendant never told Agent Grusing that blood's from an old injury, or that blood's Corey's, so that blood might be mine, or it might be a false positive due to a chimp. The defendant admits Dylan was bleeding on November 29th. And he only admits that because the FBI truck is sitting outside, and they're about to find that themselves. At trial, though, his story changes yet again to what else the blood could be about or who else it could be from. But the evidence remains the same. So as you're deliberating, when you're wondering about the blood, take the defendant's word for it. Dylan was bleeding in the living room. And for everything else to rely upon, we're going to talk about CBI and the work they did and the evidence that you can trust in reaching the right verdict. Why did he clean up the blood? Why does the defendant clean up the blood? He doesn't keep a particularly clean house, right? He doesn't have a house that's spotless. In fact, when we look at the photos from November 29th, Dylan's boarding pass from November 18th is still sitting on the bathroom counter. It's 11 days later. The pillow and the blankets are still on the couch on November 29th. The defendant cleans up the blood because he killed Dylan. He cleans up nothing else from that night. That's the only thing that he cleans up that night. Look at this in Exhibit 67. It is not a particularly clean house. Here in Exhibit 110, in the bathroom, that's Dylan's boarding pass from November 18th. It's still sitting there 11 days later when the FBI, CBI, and the sheriff's office come in to execute the court-ordered search warrant. Here we have Exhibit 340, which shows the different spots where blood was detected. 3 different tests at the scene used to find presumptively positive blood at 5 different locations. And as you know, these tests themselves are liquid, so they dilute some of the sample. So 2 of the swabs that are taken do not test positive at the lab, but the other 3 do. And all 5 of these locations indicate that Dylan's DNA is there. Then they run it with StarMix. It's a highly sophisticated computer program that in large part confirms what Rebecca Strubb found when she did the testing when it first came to CBI. Each one of these locations, particularly the one around under the carpet, says so much about what went on in that living room that night. Dylan was alive in that living room alone with the defendant, with tension, anger, and blood and DNA. But there's more. We have the pillowcase. So let's talk about the pillowcase for a minute. The pillowcase, which the defendant told Search and Rescue Dylan slept on. Or actually, that's not what happened. Search and Rescue went in the house and said, do you have anything of Dylan's? We're going to use it to track him. No. What? Dylan had a bedroom there. Do you have anything of Dylan's? No. You don't have a single thing of Dylan's? No. And the gentleman from Search and Rescue, Roy Vreeland, tells you the defendant seemed frustrated and annoyed. He's trying to get something as a scent article. And the defendant's telling him that his son has not a single possession in the entire house. There's nothing there. Nothing at all. And Roy Vreeland says, well, what about that pillowcase? I mean, if he slept here, is that where he slept? And the defendant finally says, oh, yeah, you could take the pillowcase. The pillowcase that doesn't work. It doesn't work at all with the human remains dog or the tracking dog. That is further evidence, ladies and gentlemen, the defendant is trying to avoid Dylan being found and avoid responsibility for it. But there's more. We have the human remain detection canine hitting on several locations. Molly is a certified dog, and she has a proven track record. She's been in houses where she found nothing at all, and she's been in houses and cars and places where she has found human remains. She's only had 2 false hits in her entire career working. She and her trainer have been together for years. This is the work they specialize in. And Molly hits on several locations. So you're asked by the defense to consider how long can a trained and certified canine detect human remains. And you may recall the defense called Dr. Ha to the stand and asked Dr. Ha, how long does the odor remain after someone's been killed and their body's there? And Dr. Ha said 24 to 48 hours. That's it. And he was asked on cross-examination, can you point to one study, one piece of scientific literature, anything at all to support that? No, it's just what I think. And how many searches have you been on with human remain dogs? I watched one years ago in Seattle. That's it. You can't rely on that testimony. We have Molly and the trainer who've been together and doing this kind of work for years. And her trainer's been doing the work for 20 years. Molly hits on several locations that day. 43. Outside the house, inside the house, up at the remain site. 43 positive indications for human remains. And she and her trainer did not know where Dylan's body had been. And here's what they come up with. In the threshold and over here. And this corner is key because when Dylan is killed, this couch is over here. And in different places throughout the house. human remains detection dog hits on multiple locations in the defendant's house. So in the living room, in the couch area, we have tension. We have the last text message Dylan will ever send in his life. We have the defendant later claiming we were roughhousing. We have blood. We have DNA. And we have a human remains canine. The defense has suggested to you this looks like everyone's living room. I would suggest to you this looks like the murderer's living room. This looks like the murderer's living room. Each one of these things on top of one another at all of these spots, they don't match up perfectly, and nor should they. You don't have blood and DNA and human remains all at the same places. But that amount of evidence in that small an area, with no evidence being collected or seen in other parts of the house, when we know that's the last room that Dylan was in, by the defendant's own statement, that says so much, ladies and gentlemen. We know that we have the defendant's truck. And we know, although the defense expert had no idea how long the odor of human remains can exist, we know from the study and from the trainer's work that studies have been done showing up to 677 days after human remains are removed. And we have the positive hits on the defendant's truck in a number of different locations, including the bed of the truck in Exhibit 474. We also have it on his clothes, ladies and gentlemen. The clothes that you saw the defendant wearing in the Walmart video, those same clothes, the human remains dog hits on the outer shirt, the jeans, and the sneakers, indicating that he had been in contact with human remains. After Dylan's disappearance, after the murder, the defendant's behavior is incredibly suspicious, evasive, and misleading. And the only logical, reasonable reason for this is because he's the murderer. During jury selection, one of you said actions speak louder than words. Do you remember that? Actions speak louder than words. And that is certainly true. So let's talk about the defendant's behavior after Dylan goes missing, because that says so much about what he did that night and what he's going to do to try to cover it up and keep you from reaching the right verdict in the case. He goes to his workplace and his attorney's office, even though neither is set for a particular time for him. And you can see that in his phone records, he calls the attorney twice before he goes to her office. And you can infer that he did not have a set appointment with her for a particular time. If you're trying to get yourself an alibi or do a cover-up, going to work and your attorney are two good steps to take. But the fact that he didn't have set times for either says so much. And when he shows up, he looks incredibly haggard, tired, talking to Sean Boris at United Pipeline. And Richard Swayze says the defendant appeared more sober than usual. He still remembers that moment because it was so unusual. The defendant appeared more sober, and for the first time ever, and they've been working together for a long time, the defendant stands there talking to Mr. Swayze when Mr. Swayze's trying to work. He talks to him for an hour and just goes on and on and on. They don't have any personal relationship. And here's a key part, ladies and gentlemen. The defendant tells the FBI that he left Dylan to sleep in, and that Dylan and he had a plan for the defendant to go back at 11 or 11:30 and now take him to Ryan Nava's house. That's their new plan, according to the defendant. He's going to come back at 11 or 11:30. But he's texting and calling Dylan during that time. Even though he told his son, you can sleep in and I'll come back at 11 or 11:30. This is how he's trying to create a cover story, ladies and gentlemen, and it will soon fall apart. But this is his attempt to try to cover his tracks. The attorney, the workplace, neither of which he had a set time, and then these calls and texts Dylan. Then he leaves to Rango after running his errands to go pick up Dylan for that fictional 11 o'clock, 11:30 pickup time. He tells Agent Grusing that he comes home through Bayfield in case he sees Dylan there. Now, Agent Grusing's from out of town. He had rolled down from Denver with the FBI team to help in locating Dylan. So he doesn't know what you know, which is that Bayfield is 21 miles from the house. If Agent Grusing knew it at the time, he would have said, what are you talking about? Bayfield is 21 miles from your house. How in the world would Dylan have gotten there? How would that have happened? And what would have happened to your plan to drive him? And think about the timing of this tall tale the defendant's telling Agent Grusing. He leaves the house at 7:30, Dylan's sleeping. It would take more than 4 hours to walk to Bayfield. So he tells Agent Grusing, I'm out looking for him already. It's 11 or 11:30, but I'm already on the search because I'm a caring dad. This is not the story of a caring dad. This is the story of a man who's going to try to cover his tracks so he won't be held responsible. Then he gets home and he finds Dylan's missing, and he reports it immediately. That's what you were told in the opening statement by the defendant. He reports it immediately. That's actually not true. The defendant says to Agent Grusing, he came home and Dylan is gone. And the TV is still on to Nickelodeon. And perhaps years earlier, Dylan watched Nickelodeon. Perhaps that's what he watched when the defendant had fond memories of their relationship from back in the day. But this is a kid who's texting with the N-word, and it's not Nickelodeon. And he's texting about different girls that he wants to be with, and he is a mature 13-year-old. He's not watching Nickelodeon, and he's not leaving the TV on to that channel. But this is the defendant's cover story. And he says he reported it immediately. That's what they tell you even here at the beginning of this trial. At every juncture, the defendant tells a story to try to avoid responsibility for what he did on November 18, 2012. In fact, what he did was take a nap and then report it 5 hours later. Takes his nap, he makes half-hearted attempts to find Dylan, and then, ladies and gentlemen, he goes to the Bayfield Marshal's office. As you know, from hearing Deputy Abdullah testify, he appears unconcerned and does not want to file a report. He is a father. His kid's 13. The kid is missing. It's nightfall, and it's going to be cold outside at night. And he tells Deputy Abdullah, no, you don't need to do an attempt to locate. He has no idea, actually, he knows exactly where his son is. And that's why he tells Deputy Abdullah, don't bother, you don't need to do the attempt to locate. And he declines that. And Abdullah says, you know what, you should call the mom or text the mom and see. And that's where we get the text messages between the murderer and the victim's mom, back and forth, where the victim's mom is saying, you seem so unconcerned. What are you doing right now? Why are you not anxious or upset? The reason he's not anxious or upset, and Elaine Hall knows this guy. She knows him. And she's saying, why are you not anxious? Why are you not upset? Why are you not freaked out? And he's saying, don't freak out. And she knows something is wrong. Something has happened. And if you line them up side by side and compare how the two act, you see how a concerned, loving parent acts and how the murderer who knows exactly where the body is acts. Because Elaine Hall calls everybody and throws them in a car and starts to roll. And she calls the sheriff's office. And she's the one who gets the alert put out from law enforcement by calling the sheriff's office. We know the defendant is hiding something. It's like a kid would do. When you don't want anybody to look over there, you say, hey, look over here. So the defendant's going to tell people, Dylan walked to the dam. We'll talk about that in a minute. Or to Bayfield. And his fishing pole is gone. He keeps pointing in the wrong direction. In fact, when he's up on Middle Mountain Road days later with Brandon Redwine, he tells Brandon after a short period of time, he's not up here. Brandon testified about his dad. That's when I realized he had done something. That's when I realized he knew something. How would he know that Dylan wasn't up there? We hadn't even looked. And we turned around and went the other way. He keeps pointing in the other direction. And actions speak louder than words. Search and rescue describes the defendant as tired, unkempt, laid back, nonchalant. He's not frantic at all. He also doesn't help on November 19th when search and rescue is out there. Think about that, ladies and gentlemen. He doesn't help look for his son. He turns off the lights, including the outdoor light, and the significance of that is that the night before, at 2 o'clock in the morning, that light is on. At 2 o'clock in the morning, the neighbor sees the light on outside. The next night, when his son is missing, he turns off the outside light. because no one needs to find their way home. He knows where Dylan is because he knows exactly what he did to Dylan. So he's the one person in the world who's not surprised or shocked or out searching in a state of panic. The defendant sleeps the full night on November 19th because he's exhausted. He was up late the night before. So there's no calls, no text, and no search. We have Roy Breland from Search and Rescue, who volunteers 20 days of his time. As a volunteer, 20 days of his time over the next month. This guy doesn't give it 20 minutes. And he wants you to believe that he thought his son was missing. Everyone else in the world is in a state of panic that night. It is dark, it is November, and Dylan is gone. Everyone is up, everyone is anxious, everyone is searching except for the murderer. He is home asleep, lights off. Think about a member of the family missing, just gone. And a family member going to sleep and turning off all the lights, including the outside light, while Search and Rescue is still outside looking for him, ladies and gentlemen. Search and Rescue is still out there. And then we have Elaine. She's driving from the Springs down to Durango. November 19th. It's 4:59. And she starts calling Dylan. These are all calls from Elaine Hall to Dylan. 4:59, 5:08, 5:30, 5:56, 6:12. It goes on and on. 8:37, 8:40, 8:40 again, 8:49, 9:23. He's asleep. 9:52, 9:52. After midnight. 11:31. After midnight. 1:55 in the morning. 2:35 in the morning. They're at the Bayfield Marshal's office that night, along with law enforcement, because everyone's in a state of panic because no one, except for this guy, knows where Dylan is. The things he does after tell us so much about what he did on the night of November 18th, 2012. Because the next morning, it goes on. A well-rested defendant comes outside. I want you to picture this in your mind. The defendant comes outside. Search and Rescue's across the street. They've already been looking. They're already out there. The defendant has a cup of coffee, and he sits in the chair and watches. He just sits there and watches. There's one reason that the defendant doesn't say, "Hey, any news on my son? Hey, did you find Dylan? Hey, where are you guys looking today? Any updates?" He already knows the answer. He already knows the answer. There's no other logical reason that you sit down and have a cup of coffee when everyone in the world, including Search and Rescue volunteers across the street from your house, are looking for Dylan. He sits down and has a cup of coffee. Let that image stay with you as you go back to deliberate, because it's completely consistent with the defendant knowing what he did to Dylan and knowing where Dylan was, and inconsistent with anything else in the world. The defendant deliberately and repeatedly misdirects investigators. As the defendant makes statements to law enforcement and to the FBI and to other individuals, he's going to try to cover up the things that he can't admit. But if you look closely, you'll see even the truth in those details. It's no coincidence that Dylan's last text ever is sent around the same time they're roughhousing. And by the way, when you read the defendant's written statement, his full written statement, the defendant says, "We started roughhousing and tension started to subside." Does that sound normal to you? We started wrestling and then the tension got better? But the defendant says that's happening right around the time Dylan sends his last text ever. They're having physical contact. Dylan's phone goes dead right around the same time the defendant claims he went to bed. These are not coincidences, ladies and gentlemen. The defendant's trying to shroud the truth from you because he doesn't want to be held responsible. Dylan walked, according to the defendant. He tells Roy Breland he walked to the dam. That's 9 miles. He says he walked to Ryan's house, 21 miles away. At the start of this trial, in his opening statement to you, the defendant said Ryan Nava lived right down the road. True, but it was 21 miles down the road. And Dylan may have walked there. That's a 42-mile round-trip walk that the defendant, in his opening statement, said to you was a possibility. Dylan went fishing. We've heard a lot about that. The defendant tells Agent Grusing, I looked for the fishing pole, this 6-foot fishing pole, for 1 hour. I looked in all the logical places. Anywhere where it would be kept, I looked, the fishing pole is gone. He tells everyone the fishing pole is missing. Go look down by the lake, the fishing pole is missing. Go look down by the dam. He may have gone fishing down there and walked 9 miles to the dam, even though we know from Dylan's friends and family he would never do that. That's not behavior he would engage in, walking that far to go fishing by himself. He tells Elaine in a text message, the fishing pole is gone. And as a result, we know that efforts are diverted away from the defendant's dump site for Dylan on Middle Mountain. And all the efforts are going to the lake. They bring in a dive team from New Mexico. And as you think about how many people worked on this case, how many people responded to the calls for help, how many people tried to assist in finding Dylan, think about that dive team for a minute. This team rolls up from New Mexico, and they go plunging into Vallecito Lake in November, because this guy says the fishing pole is gone. And in some ways, he's right. Because when the FBI, CBI, and the sheriff's office search his house, the fishing pole is gone. It's not there. It's not there because the defendant's trying to cover his tracks. And it's not until after Dylan's remains are found that he finally turns over the fishing pole to investigators. And then we have the defendant's lack of action, any action at all, completely consistent with being the murderer, who knows where Dylan's body is, and inconsistent with any other human being, let alone family member, in the weeks and months that followed Dylan's disappearance. He knows where Dylan is. So the defendant calls Dylan at 7:19 a.m. on November 20th. According to the defendant, Dylan has gone missing sometime around mid-morning on November 19th. He calls Dylan on November 20th. That's the last staged attempt he'll make to reach Dylan for the rest of the year. You are here, ladies and gentlemen, because you have common sense and you have life experience. And I would ask you to ask yourselves what you would expect from a parent whose kid has gone missing the day before. And now he doesn't call or text Dylan that week, the next week, the following week, the week after that, or the week after that, or the next one after that. And he's also engaging in no attempts to help locate his son. 0 attempts to try to contact his son, and only participates in one search in a different area. Maybe he's lazy. I can't tell you what goes on in his mind. I can't tell you that. Maybe he thinks he's outsmarted everyone. Maybe he thinks the story is going to be enough. He certainly underestimates the continued efforts of Dylan's family and Dylan's friends, who keep looking, who hold a vigil, who are determined to find Dylan. He certainly fails to recognize that the sheriff's office and all the people who work there are going to do their very best to find Dylan. And they're going to call in all the assistants and all the experts they can to help locate Dylan and then investigate and prosecute his killer. Most of all, the defendant taking no action is completely consistent with him having disposed of Dylan's body. So the FBI arrived to assist in locating Dylan. Picture it. Dylan's been gone about a week, and the FBI rolls into town to help locate Dylan. If you're a family member and the FBI shows up at your house, or shows up at your house, and your kid's missing, you're in one of two camps. You're either in the, thank God the FBI is here, or you're in the, oh God, the FBI is here. The second camp is you are the murderer. The first camp is you are a parent who's hyper-concerned, who's doing everything he or she can to find your son. And is just glad that the reinforcements of the FBI are coming in, including Agent Grusing, who gets the written statement from the defendant on November 26th in his own words. You can read it. It says, tell me every detail, no matter how small. This is about the disappearance of his son. It talks about the roughhousing and the tension starting to subside. No mention of injuries or blood. Also, no details of how the night ended with Dylan. If someone is missing in an individual's life, and they ask you, when you saw them last night, how did it go? You end with I said goodnight, I gave him a hug, I gave him a kiss, I gave him a high five, he went to bed, I went to bed. Those details are missing because those details did not happen. And in the written statement, there's no mention of injuries or blood. And then Agent Grusing has a follow-up discussion on November 26th. Defendant talks about the relationship, talks about Dylan being upset, standoffish, being upset about the iTunes card, which we see him looking at in the Walmart video, and repeatedly blaming Elaine, which really strikes Agent Grusing as strange. And the defendant talking about the fact that they'd been on that trip to Chicago and he'd gone on Dylan's phone without Dylan's permission and had seen what Dylan was sending. Remember those text messages that Dylan sent to Corey saying, send me the poop pics over and over and over and over and over again? The defendant in that interview on November 26th says, I tackled Dylan onto the couch. 13-year-old boy who wants nothing to do with his father. Tackles him onto the couch. And Agent Grusing, because this is what the FBI does, and they're the best of the best, said, any blood, any injuries at all? No, nothing at all. Defendant says he either went fishing or he ran away because of Elaine. November 27th, Agent Grusing is back. He has follow-up questions. The defendant answers. He's holding a pillow. He appears like he was either intoxicated or sad. And the defendant tells the whole story yet again. It's basically the same, including no blood and no injuries. November 28th, after law enforcement briefs together, and they realize we have inconsistent statements, there's concerning actions and inactions by the defendant, and given the defendant's behavior and what they've learned from Elaine and Corey and others about the incredibly toxic relationship with the defendant, and the fact that Dylan did not want to go but only went because a judge made him. They go back on November 27th, and they ask on November 27th, can you come down on November 28th? We want to talk to you. And the defendant's a no-call, no-show. The FBI works with the Lahada County Sheriff's Office, and they get a court-approved search warrant. And on November 29th, they go. And Agent Grusing intentionally sets up outside the FBI evidence recovery team truck and says to the defendant, the truck is from the evidence recovery team. They do an extremely thorough search. They're going to search the whole house. And for the first time in 10 days, to anybody, the defendant blurts out, you know what? Dylan was bleeding from a cold sore. It was just dripping blood onto the floor. They spent 5 hours together. The fact that that detail had never been shared tells you everything you need to know about the defendant's guilt. And what happens next confirms it. Because Agent Grusing says, well, you know what? I'll be able to confirm whether he was dripping blood from a cold sore by talking to the flight attendants or talking to his family or getting a picture like this one or the other ones you've seen. And the defendant realizes that that story is not going to work. So for the first time ever, he says he hurt his lip on a Nerf football. You've seen the Nerf football. You felt it as it went around. I watched you squeeze it. You sat in that living room across the hallway because we wanted to show you there's no way a Nerf football can be thrown at that distance and crack open someone's mouth. There's also no way this story makes sense. And the defendant's telling it for the first time because the evidence recovery team has arrived. And they are, in fact, about to find blood in the defendant's living room. The defendant goes on to say, Dylan spit blood on the floor. They drive to the FBI office for a longer discussion, and he tells Agent Grusing about what was going on during that day. He also gives a really interesting fact for you to consider as we think about what happened to Dylan's belongings, which is, I took his black shirts and shoved them back into his backpack and zipped it shut and said, I'm not your mother. His son had just arrived for a 1-week stay. The house is not that clean. This is one of those things that the defendant shares because it's partially true. He did touch the black shirts. Dylan's found dead in the black shirt. and he did touch the backpack, which is never seen again. But it's certainly not because he's just getting tidy. And even then he says, I'm not your mother. That story is not true. The defendant argues a whole lot of things here at trial, ladies and gentlemen, but I would ask you to keep in mind what he told Agent Grusing on November 29th, 2012. What he tells you through Agent Grusing is there's a less than a 5% chance Dylan's run away. He was not kidnapped. This is the defendant, given where he lives. Possibly an animal attack? Asked Agent Grusing. What about a bear? And to this, the father of the missing son, who's been missing for 10 days, lights up and becomes animated. And Agent Grusing tells you how concerned that made him. You're not supposed to be excited about a bear eating your kid. Why do you seem animated and excited right now? And the conversation turns, and Agent Grusing confronts him and says, you seem to be involved in it. Now's your turn. Now's your chance to tell me. And Agent Grusing says, you're on the side of a mountain, and the boulder is coming down. You can either get out of the way, or you can just let it roll down upon you. That's my way of saying justice is going to come. Think about a parent who is not the murderer, who hears this from the FBI. If you're the murderer, you react exactly like this guy did. He slumps his shoulders, he goes down, and he says, I have to start thinking of myself. And that's the end of the interview right there.
Mr. Doherty, you have slightly less of the word.
Thank you, Your Honor. The defendant dropped Dylan's body over a trail, so he knows exactly where Dylan is, and this is why he's telling Agent Grusing these falsehoods. The defendant disposing of the body, he did that to try to cover his tracks. He did that to try to destroy the evidence. He did that to make sure, or to try to make sure, that justice would never come down. But it's coming, because the body is ultimately found. And the body reveals to you that it's a murder. And the fact that the defendant disposed of his son's body the way he did reveals that it's not an accident what happened in the house on November 18, 2012. Certainly not an accident. And the body itself, it was recovered when it was, reveals blunt force trauma to Dylan's skull, Dylan's head, and sharp force injuries to the right zygomatic arch of his skull. And by getting rid of the body, the defendant was able to tell people Dylan just simply disappeared. He went fishing, he went for a walk, something must have happened, maybe it was an animal. He's ready to rattle off any option. And it's because of what the defendant did to his son. It's because the defendant left Dylan's body out there that Dylan is eaten by scavengers. He's eaten by animals. And his remains are spread out all over the place. And his family is left with so little of Dylan. But enough that the experts that you can rely upon were able to determine this is a homicide. And the injury was not just one place, but two places. And everything the defendant does after is consistent with murder in the second degree. The defendant knowingly killed Dylan Redwine. He's guilty of child abuse resulting in death. We talked in jury selection about what it means to act knowingly. We talked about the difference between husband-wife altercation where one of them waits for the other to come home and has a handgun. Do you remember this? Handgun and shoots the person on purpose. That's intentionally. Murder in the first degree. Murder in the second degree, when you act knowingly, is you're having the discussion in the kitchen, as we described in jury selection, and one party becomes upset and hits the other in the head during the argument with a frying pan, knowingly. That's what we have here. Let me ask you a question that I'm then going to answer, which is, what if the defendant succeeded and the remains were never found? What if Dylan's body was never found? He almost got away with it. He almost succeeded in making sure that the remains were never found. Another year, maybe 2, maybe 3, or if the Platte County Sheriff's Office didn't give this their all, along with volunteers from this community and search and rescue, perhaps Dylan's remains would never be found. And I'd be right here, because he'd still be guilty of murder. And it'd be what's called a no-body homicide, where we know there's one person in the world who had the access, the opportunity, and the reason. And that person killed the victim and succeeded in getting rid of the body. And that happens. But it didn't happen here. because Middle Mountain was searched extensively, exhaustively by search and rescue and by volunteers and by Dylan's family and Dylan's friends, but not by this guy. Because he tells them he missed the emails and he missed the phone calls about it because his cell phone was broken. And we know from investigative accounting that that story is actually, again, not true. Then it goes away during the time of the Middle Mountain search. And the defense will tell you, oh, it was because he was working. But then ask yourself, well, why doesn't he call once between June 21st and June 25th to ask for an update on the search? And on June 27th, he's told his son's remains have been found. Your son's remains have been found. And later the same day, he's on the phone with Brandon, his son, who for a long time had no contact except a court order that forced Brandon to be with him on one occasion, who suspected him of being involved in Dylan's death. And he tells Brandon, without the skull, they're not going to be able to figure out if it's blunt force trauma or not. His son had just been found that day, and that's his reaction. He cries when he's with law enforcement for a few seconds. He's on the phone with Brandon later saying, without the skull, they can't prove blunt force trauma. And Brandon says, what's she talking about? And contacts law enforcement that same day. It's his son. Think about how well Brandon Redwine knows this guy. And he knows based on that, I need to contact law enforcement. And the remains are found only because of this type of effort you see on the screen, ladies and gentlemen. Climbing up the steep slope to the trail used by the defendant to dump Dylan's body. Hand over hand, climbing through there, doing this grid search. And as a result of that kind of effort, they find the first primary remain site, which is 8.6 miles from Mark's house. And then they find the cranium later when the Fosters are hiking, and I'll talk about that in a minute. But when you look at this map, and you look at the fact that Mark was at the end of this dead end, the remains are in the first place you would leave them if you're Mark Redwine, and the last place in the world anybody else would have a reason to be. They're close to his house. And it's called the primary remain site. And it's a classic dump site. And that's the words of Dr. France, who took the stand and testified before you. And she's an expert in this. And this is what she does in her work with necrosearch. They go out and they look for bodies. But we actually, before I talk about Dr. France, we have two people who know the subject matter really well. We have two people who know the subject matter about where the defendant would leave Dylan's body after killing Dylan on November 18, 2012. One of them knows the subject very well. That's Betsy Horvath, the defendant's ex-wife, who calls law enforcement unprompted, just a few days after Dylan's disappearance, and says, based on what the defendant has told me in the past, I think he would take Dylan's body and dump it in the mountains and not make any effort to bury the body. This is in November of 2012. It's months before the remains are found. And a woman who knew the defendant better than most people, his ex-wife, is calling law enforcement to say, check the mountains and I bet you didn't bury the body. And then we have Dr. France, who talks about, in a case such as this, the suspect will be familiar with the area. Check. Remains close to a road or a vehicle access point. Check. Footpath downhill from that road. Check. And consider the physical size of the suspect and the victim. In this case, we know Dylan was much smaller than the defendant. The defendant having the remains found close to his house tell you so much. And the fact that there are two different locations tell you even more. The defendant had placed the body in the perfect place in which he had the limited time to do it, when he had that light on at 2 o'clock in the morning. And it's also the last place in the world anyone else would do so. Now, from the very beginning of this trial, and actually from the very beginning of this investigation, the defendant has argued Dylan was not murdered. It is not a murder. Animal attack, something else, but not a murder.
Present our argument, Judge. Again, jury will remember with their collective memory what's been argued or opening statements, and they will be able to listen to both sides in their closing arguments. Go ahead, Mr. Doherty.
Thank you, Your Honor. When you showed up for jury selection for this case, you might have thought, they're going to say someone else did. The defendant knows that if it's a murder, there's only one logical person, and it's him. He's the last person to have that contact, access, and reason to kill Dylan. The defendant will tell you it's Mother Nature, because he knows once you determine it's a murder based on what Dr. Kurtzman said, and what Dr. France testified, and all the evidence in the case, that he's the person who's held responsible for it. That's why he tells you all the injuries are from some other cause, not from a murderer. Because once you see the evidence and hear the testimony that it's a murder, you know it's him. Who had reason to take Dylan's backpack, ID, debit card, iPod, and phone? Let's start with the backpack. If Dylan were actually going fishing, he would have left his backpack at home. If you're hanging out with his friends, backpack at home. He had no reason to take the backpack with him. The defendant's story is he was supposed to be coming back to pick up Dylan at 11 or 11:30. The defendant admits having contact with the backpack, pushing the shirts into the backpack, and that's no coincidence, ladies and gentlemen. The backpack disappears forever. So does the cell phone. There's no animal or stranger or Mother Nature who's going to take the backpack and cell phone of Dylan Redwine. The only person, the only creature in the entire world to do it is the defendant. Because he wants to make it difficult for law enforcement to identify Dylan, and also to make sure that it can't be traced back to him. So he takes Dylan's phone, he takes his iPod. In a lot of ways, when he took those things, he cut Dylan's life and lifeline. And in fact, speaking of cuts, I'd ask you to remember the defendant's expert who said Dylan's headphones, exhibit 320, appeared to be cut. Or perhaps by a claw. And you can look yourself at 320. And this was the defendant's expert. Dylan's debit card. Let's talk about this briefly. We know Dylan has a debit card. The only debit card, and it has its name on it. And there's a balance of $2,000.06 in the account. And we see the text messages between Dylan and the defendant saying, can you send me the PIN number, please? Because the PIN number was sent separately to the defendant's house. And Dylan texts him on those dates you see on the screen, the 3rd and the 4th and the 16th of September, and Dylan's trying to access the bank account. Dylan has the bank card on him. He has the debit card. It's in his possession. On November 18th, he arrives. He spends a very limited amount of time with the defendant. When the defendant tells the stories about what happens between he and Dylan, he never once mentions the debit card. And yet, when a warrant is issued later, it's found that the defendant's in possession of Dylan's bank card. This is the same guy who told search and rescue, I don't have a single possession. I don't have anything at all. And in fact, while his son was still missing, the defendant transfers $2,000 out of Dylan's personal account. His son is missing, and he's taking his son's money out of his account. His son won't be able to access it then or ever. But the defendant does it because he knows Dylan will never have a need or the ability to access it again because Dylan's dead. But when you go back to deliberate, ask yourself, how did the defendant end up with Dylan's debit card? And the answer, ladies and gentlemen, is he took all the possessions and got rid of everything that could tie Dylan to him, tie the body to him, except the debit card, because the debit card could potentially have value for him. He was able to transfer that money by going to the bank. But he took all the money out of his son's account, $2,000. He left 6 cents in his son's account when he thought his son was missing. And then we have the partial cranial. You heard the testimony from Dr. Kurtzman and Dr. France about the sharp cuts to the right zygomatic arch and the blunt force trauma to the front of the head. And it's the very reason the defendant wanted to hide this part of Dylan's body. He didn't want anybody to find it. He didn't want it to be seen. But it was found in enough time for the experts to figure out what happened. And you can look at the cranium as a model that Dr. France brought, and you see the radiating fracture from a blow. You heard Dr. Kurtzman talk about how there's a fracture to one's face that could cause a radiating fracture up into the head if someone is slammed into something forcefully, like a coffee table, or something is slammed against their head forcefully. And it's called homicide. We have it here on the day it was found by the Fosters and law enforcement in 2015. And you see the result of the blunt force trauma, the fracture of the skull. And then the cuts. The defense expert, Eric Smith, told you these cuts seem to him, in his expert opinion, to be the result of slicing, cutting action. You see it there as well. This defendant is guilty, ladies and gentlemen. He is guilty of murder in the second degree and child abuse resulting in death. He was the last person seen with Dylan. When Dylan goes completely dark and is never heard from again, he's in a living room with this guy. He's angry and upset and rageful. Dylan's blood is in his living room. He has the smell of a dead body in the same room, on his clothes, and in his truck. And he has Dylan's debit card. His changing stories and behavior are incredibly suspicious and evasive until you realize it's completely consistent with a murderer. He lives in that isolated area right where the remains are found. And blunt force trauma and sharp force injuries are found on Dylan Redwine's head. During the trial, we talk about cuts to the right zygomatic arch. What we're talking about is the murder of a 13-year-old boy. And the defendant is guilty of it, ladies and gentlemen.
All right, ladies and gentlemen, we're going to take a break. It'll be lunch is here. I got word that lunch was here, so you will have to remain together. Cindy will make sure that you stay together. Remember, by admonitions, you've heard some of the closing arguments. You haven't heard all of them. There's another instruction in verdict forms that we need to go over. So it's too early for you guys to start talking about this case and making a decision from the case. So do not discuss this case amongst yourselves or anyone else. Don't talk with any witnesses or the defendant. Don't gather any information on your own. We will start up again at 12:20. And with that, we'll be in recess. Is there rights for the jury? All right, we'll be in recess.
Thank you, Your Honor.
Come back there.
And we're gonna get some complaints then, which is fine. Let's see if we can kind of get through it.
Yeah.
You're front and center. Put 'em over here. That's good. Okay. That's good. And they'll just see your hands right there. Yeah, that would just be starting to show. Thank you. Everybody rise for the jury, please. All right, we can be seated. Gonna let some of the commotion die down, so just a second. When you're ready, Mr. Bogan.
May it please the court.
Go ahead.
My presentation doesn't start in Biofito, doesn't start in Colorado Springs, doesn't start in Durango. Starts in Bakersfield, California. There's a crew out there working for United Pipeline. Crew leader, the man charged in this case, Mark Redwine. He's in his truck away from the men that he's supervising, and I think it was evident in the testimony that working in the fields for United Pipe attracts and employs a rough and tumble sort of crowd. And that's okay. The leader of this crew in Bakersfield on a hot summer afternoon, he's not screwing around with his coworkers, he's not getting up in their business, not making sure the pipelines are running correctly. He's in his truck, looking at his phone. Pictures of his son, who he's estranged from, who he doesn't have a good relationship with. So he's losing. He's looking at the pictures of his son playing ball, and he's weeping. And he can't help it. He's working in a place where show of emotion, crying over a cell phone is not what you do, and is not generally socially accepted. And he's crying when he's looking at these pictures of Bill and Redwine, because he loves them and he misses them. And Freddie Crasium, you heard him testify yesterday, he sees this man hovering over his phone, over the pictures of his son, weeping, because he loves him. Many, many months down the road, years, he sheds those same tears, and Tom Cowling tells him they found Dylan's remains. He loves Dylan, misses Dylan. He wants Dylan in his life. And as the prosecution says, use your life experience, use your common sense. If you want one of your children, your son, your youngest son in your life, you don't kill him. You bring him into your life. That's what Mark Redwine wanted. Even using their analysis of Occam's razor, what's the simplest answer to what's going on here? You want your son in your life, if you want a relationship with them, you don't kill them hours after they arrive to come visit you. I'm going to ask you to reflect on the evidence in this case, the lack of evidence in this case. And on behalf of Mr. Redwine, I'm going to ask that you return to not guilty verdicts. Not guilty of murder in the second degree, not guilty of child abuse resulting in death. You've seen a lot of witnesses testify, and there's been a lot of questions about why are you testifying for this side? Why is this side calling you? What are your motivations? What are your biases? I think it's pretty evident. I'm a defense attorney. Moran, the defense attorney. Mr. King, the defense investigator, so is Mr. Lister. Sometimes it gets posited. Are you representing this man? You have to. That's even been posited in different ways to different witnesses. We stand shoulder to shoulder with Mr. Mark Redwine, because it's our honor to stand with someone who's wrongly accused. It's our honor to defend someone and fight and object and argue and introduce evidence. It's our honor to do that, especially in a case where someone's been wrongly accused and the evidence is so thin and the emotions are so high. The not guilty verdict from this case flows from the evidence in this case, the lack of evidence in this case, science, the testimony, and the not guilty verdict flows from what you know about this case now. You guys have become experts on what's going on in this case, more so than probably a very small number of other people in the world. And it's what you know about this case, not what the prosecution wants you to think happened in this case, not what the prosecution wants you to speculate about what happened in this case, but what you know in the evidence and lack of evidence. We do these trials in a special building, a courthouse. We got rules. People can talk at certain times, and there's stuff you gotta do when you're sitting as a witness, there's stuff you gotta do when you're, asking questions. And all these rules, this edifice that you sit in now, it exists for victims, for families. It exists for Mr. Mark Redwine. And out of all this process, we lurch slowly towards some definition of justice. On a grand scale, and more importantly, on a small scale in this case. And I submit to you, justice does not get achieved by returning a guilty verdict when the wrong person has been charged. Justice is not achieved, closure is not achieved when the wrong person gets convicted. Now, this edifice, this process exists because the Redwine is presumed innocent. The burden is on the government to prove to your satisfaction unanimously, otherwise beyond a reasonable doubt. But because of those rules, I get to talk once today. Prosecution gets to bat twice. So I'm going to say my bit on behalf of Mr. Redwine. Mr. Doherty's going to listen. He's going to get up. He gets to talk one more time. And as you listen to him talk, think about this edifice. Think about why this building is here. And think about what Mr. Redwine would say. Think about what the evidence would say, the lack of evidence would say to you when Mr. Doherty gets back up to talk in a little while. I submit to you, because of the evidence and the lack of evidence in this case, justice is a not guilty verdict. Justice and the verdict in this case should flow from truth and facts and science. It shouldn't flow from hatred, disgust, bias. It shouldn't flow from speculation, innuendo, or unjustified interest. The verdict in this case should not flow from what you think might have happened. You're confined to the evidence and reasonable inferences therefrom. I listened to Mr. Doherty talk. I didn't count them all, but I heard him say these phrases a lot when he was addressing y'all. A lot of the time, he'd say, maybe it was this. Maybe this happened in the living room. Maybe this happened in the living room. You think maybe this happened. You think this happened. I can't tell you what happened in the living room, November 18th, 2012. After 9 years, 5 weeks of trial, all this investigation, they can't tell you what happened. He said, can you imagine? Can you imagine if this happened? Can you imagine if that happened? Can you imagine if he said, F you? Can you imagine if he said, hey, shit-eating shit-eater? Can you imagine that? Or what if this happened? What if this happened? Maybe this happened. When someone's on trial for murdering their youngest son, and the prosecution's thesis is what if, or maybe, or can you imagine? That's a window into how weak the evidence is in this case. When the thesis of the government is, can you imagine? What if? Maybe this happened. When they're starting off with maybe, your deliberations end with not guilty. These are the bullet points. This is what I'm going to talk about while I got your attention this afternoon. As I've listened to the testimony and looked at the evidence, I submit to you respectfully. The government's case is based upon the manipulation of science, targeting someone, in this case, Mr. Redwine. It's easy to hate and dehumanize.
Your case flows from a biased investigation and an impossible timeline. And I'm going to talk about each one of those in turn. And I'm going to beg your patience while I do all that. But before I get into that, I got to talk about some other stuff first. Your verdict should flow from facts and science. Who you believe, who you don't believe. Maybe you believe part of it, maybe you believe some of it, maybe you don't believe any of it. But justice and verdicts flow from facts and science, not speculation. One of the instructions you got from the court, and we talked about it during jury selection, was beyond a reasonable doubt. And as you can read, and you actually have this instruction in your binders, the doubt based upon reason and common sense. That's why we use the term common sense a lot during closing and opening arguments. It comes from a fair and rational consideration of all the evidence, lack of evidence. Reasonable doubt is not vague, speculative, or imaginary doubt. It's such a doubt as would make reasonable people hesitate to act in a matter of importance to themselves. We talked about how this is lawyer talk, law school talk, all during jury selection. But if the lack of evidence, the evidence itself, the uncredible evidence, makes you hesitate during your deliberation, at the conclusion of your deliberation, if you are still hesitating, as you would in a matter of importance to yourself, then the verdict is not guilty. Reasonable doubt resides in that hesitation you feel in your stomach, in your mind, when you think about the gaping holes of evidence in this case and how the prosecution's theory in this case runs contrary to science. It's that hesitation you feel in your mind, in your heart, in your stomach. Beyond a reasonable doubt, and I don't even think they can get this far. It means if you think, well, I don't know, maybe he did it. If your consensus is maybe he did it, the verdict is not guilty. Well, I don't know, there's the last person to see him according to the prosecution, and, you know, Dylan was walking 2 feet away from him at the airport, so he probably did it. Probably. He was not guilty. Well, you know, they called this one human remains detection dog expert, and they called the other one. I don't know what happened. You don't know what happened? That's not guilty. The thing about reasonable doubt is that don't have to be unanimous. Reasonable doubt can be something different for each and every one of you. Reasonable doubt can be the fact that the most overwhelming evidence of injury to Dylan Redwine is animal scavenging. For another one of you, reasonable doubt may be the absolutely underwhelming, pedestrian, unremarkable DNA evidence in this case. Another one, you might have reasonable doubt because you just don't think that dogs can tell people that though something is not there right now, that thing was probably there about 110 days ago, based upon the way the dog sits and looks at its owner. Reasonable doubt might be that there is DNA from another man found in the vicinity, in the same place as the first set of remains. But you guys don't have to be unanimous in reasonable doubt. It can be something different for each and every one of you. Philosophically, reasonable doubt flows from the government being unable to produce to you any sort of weapon. Reasonable doubt flows from the government being unable to articulate to you over 5 weeks what the cause of death is. Reasonable doubt flows from the fact that there's no evidence of a fight, that there is no evidence of cleanup. There's no credible evidence. and we'll get into this, I got the afternoon, there was no credible evidence of motive. Reasonable doubt flows from the fact that nobody on the day after hunting season was over, when there's a lot of traffic in that part of the world, nobody saw Mark Redwine drive to that little neighborhood up there by the campground, go to the general store in Vallecito, take a left and drive up Middle Mountain Road. And reasonable doubt also flows from the fact that the government, the prosecution, the attorneys from Boulder and Durango still can't provide you an explanation of what happened. So as you look at the evidence in this case, as you look at the science in this case, as you look at the lack of evidence in this case, as you look at the credibility of certain witnesses, you are obligated, as the court has armed you with this instruction about reasonable doubt, to see it through that filter. This is what the government has provided you with. You've heard testimony, there was a bad divorce. We'll get into that. But Dylan did not want to go to Vallecito. The pictures. Walmart. He had plans to see his friends. Still more stuff about the pictures. You heard about the baseball road trip. The front porch light apparently being on at 2 o'clock in the morning. That Dylan was an almost habitual texter. They provided you all this prequel, and they provided you this information. 1.9 nanograms of presumptive blood. That's the one portion of biological material in the living room that's not a mixture. That's the one that was a match to Dylan Redwine's blood. And as we know, 1.9 nanograms is 1.9 billionths, not billions, billionths, TH. 1.9 billionths of a gram. They presented you a normal looking living room. Evidence that the postcranial remains were scavenged. Provided you evidence. Cranial fractures, cranium, skull, bone. Cranial fractures consistent with taphonomy, which means natural causes. They provided you with 2 minuscule, thinner than a millimeter, marks on the zygoma. And they've also presented you with testimony of dogs making their owners happy in the form of human remains detection dogs. What they have not provided you with, the 0 here, is what they think happened. It's what happened. And as they said, as Mr. Doherty said, he can't tell you. And if the government, if the prosecutors, if the La Plata County Sheriff's Department, Federal Bureau of Investigation, Colorado Bureau of Investigation, National Forest Service cannot tell you after 9 years what happened because they don't know, if they don't know, you don't know. You may not like the pictures of Mr. Redwine. And you may not approve of the way he handled himself during the search for his son. And you may not approve the way he handled himself during the divorce. You may not approve a lot of things he does. But if they don't know what happened, you don't know what happened. If you don't know what happened, regardless of your opinions of the defendant and how he comported himself while his son was missing and dead, you must return verdict of not guilty. The verdict form does not say, do you approve unanimously of how this man acted when he found his son was missing? The verdict form does not say, do you approve of the way this man spoke to his other son, Brandon? The verdict form doesn't say, unanimously, would you, as loving parents, children, family members, have done something different? The verdict form is limited to the crimes they charged him with. The verdict form is limited to the story told you, we don't even need remains. We'd be here even if there weren't remains. We would go on innuendo and these facts alone. That's good enough for us. We'll get into the bias investigation in a little while, please. Point being, you gotta know what happened to convict. If you're gonna convict someone of killing their youngest son, you have to know what happened. And if you don't, without hesitation, you must return a not guilty verdict. As I understand the government's case, there's 5 parts. The father, Mark Redwine, the drunk, cross-dressing, feces eater, with homicidal rage about his proclivities. They allege his youngest son, Dylan, confronted him about the cross-dressing, feces eating. So he killed his youngest son, decapitated him, dismembered him, and spread him around the hills with pathological surgical precision. To navigate to a guilty verdict, you got to buy into all 5 parts of that. You got to buy into all 5 parts of that. You have to buy into that as you look at the elements of all the charges here and buy into that beyond a reasonable doubt without hesitation. If one part of those 5 parts doesn't work for you, that's not guilty. And as I'm going to talk about here in a minute, their theory defies reality, facts, science, and common sense. You don't have to be a scientist to get to not guilty here. You just got to have common sense. Science kind of helps a little bit, though. Common sense begs the question here. Is there more evidence of a young boy leaving his house, an animal predation and scavenging? Or is there more evidence of this unsubstantiated, ghoulish fantasy that the prosecution has posited? When you look at the evidence, right? When you look at what was found, what wasn't found in Middle Mountain, what was found, wasn't found in the house, is there more evidence of animal damage? Or is there more evidence of this ghoulish, feces eating pictures, temper tantrum, killing, decapitation, dismemberment, driving into the hills, spreading dead body parts all over Vallecito? I mean, that's not a bad place to start your inquiry. What do we got here? Targeting a defendant who's easy to dehumanize. Why is he easy to dehumanize? Government case. Is it easy to dehumanize Mr. Mark Redwine? Yeah, they got the pictures of him eating feces out of a diaper. Or cross-dressing, posing, taking selfies. That's pretty easy. Is there any credible evidence about him having a homicidal rage about the pictures? I submit to you, I'm going to talk about it in a while. No. Is there any evidence, as you reflect back on what you have seen and heard over the last 5 weeks, is there any evidence Dylan confronted him about the pictures on November 18th? I submit to you, there's no evidence he killed his son, and we'll get into that in a second. Is there any evidence that a man who works as a supervisor in the oil fields for United Pipeline has the know-how and ability to decapitate, dismember his son, clean up the entire place where they think this happened with surgical pathological precision, and then take those body parts, spread them out all over the area outside of Vallecito? Is someone capable of doing that, given their education and experience? And I submit to you, there's no evidence. You could have been able to do that. Please. So we know the government's case is based on the pictures. They introduce the pictures as evidence. They want you to believe that these pictures will provide some enlightenment to you about the motive that they ascribed to Mr. Redwine for killing his youngest son, whom he loved. They introduce these pictures, but they don't want you to look at them. So I'm going to show them to you. Do not fall for that. The prosecution likes these pictures a lot more than they like the tangible and scientific evidence in this case.
They like those pictures more than they like the fact there's uncontested damage by animals to the remains. The marks on the cranium are consistent with animal damage. They like those pictures better than the fact that the DNA evidence is contradictory and underwhelming. They like those pictures better than the dog alerts being unscientific, that the timeline makes no sense, and that there's no facts in hand as you go to the deliberation room to support some sort of picture compensation theory. All right, what can you think? All right, you got these photos. No one wants to look at them, but they're in evidence. Prosecution is saying this is going to possibly provide you with insight into what they say the motive of Mr. Redwine was to supposedly kill his youngest son. We talked about this during jury selection, but your commitment, the rules, the law that the court has provided you don't stop and end at jury selection. They don't stop and end, really, until you render a verdict. And you may only view the pictures for the sole purpose of seeing if that helps you understand what their thesis is, what their argument is regarding why a man who fought for the custody of his youngest son during divorce proceedings for at least 5 years would kill his son. And if you do not confine your analysis of those photos to the sole purpose of, does this help me understand what they're describing as motive, then you're coloring outside the lines. You got to throw the handbrake. You can't do that. And every one of you has assured us during jury selection that you can do that. And I have faith in the system, has faith that you will. But do not get washed downstream by the photos. Do not get washed downstream. Say, well, the person who engages in this sort of conduct is probably a pretty freaky, bad person. And because they're kind of a freaky, bad person, they probably would be the sort of person to kill their youngest son after they fought for him to get custody of him after a really bad divorce for 5 years. Can't do that. You look at him, you're like, does this motive make sense? Does this help me understand what they're saying motive is? Please. We can skip this slide, I think. Use your common sense. Let's keep going. I did a lot of slides. When you go to the deliberation room and you reflect on what the prosecution has said about motive, if you acknowledge there is no testimony and no evidence that on or about November 18th, 2012, that Dylan confronted, questioned, asked, heckled Mark Redwine about the photos, if you acknowledge that that evidence does not exist in the record that's flowed from this witness stand, if you acknowledge that there is no evidence of that, if you acknowledge that that motive, that we think that maybe Dylan, a 13-year-old boy, and we're not going to say it was the only 13-year-old boy who was having a difficult time with his dad. If you think to yourself, well, we think that Dylan was a 13-year-old boy who was having a difficult time with his dad, didn't want part of that relationship, and either told his dad, fuck you, shit-eating shit-eater, I don't like you because of these pictures, you're a bad dad, don't talk about my mom that way. If you think that maybe he did something like that and that triggered his dad to kill him in some way or another that we can't define, if you acknowledge that there's no evidence, there's no there, not guilty is the verdict. You must return without hesitation. Which comes back to what they would say is the theme of Mr. Bogan's presentation. Are you going to rely on evidence? We'll get into the evidence in a minute. Or are you going to rely on speculation? The speculation being, according to the two women who went to Mr. Redwine's house, on the same day he found out definitively that Dylan was dead, and yelled at him from a car at his house, and drove up right to the property line and started yelling at him.
do you believe them when they say that when you call out Mark Redwine for being a shit-eating shit-eater, he goes in homicidal rage, he kills you? So is that what you want to hitch onto? Or do you want to look at the evidence and science and lack of evidence in this case? And I submit to you, I think it's pretty obvious what I'm asking you to do. I'm asking you to look at the evidence. I'm asking you to think about the testimony. I'm asking you to think about what we are actually dealing with here and not the raw emotions of a community and family getting absorbed by the tragedy of Dylan going missing and Dylan's death. We can skip this, I talked about that. Let's talk about the manipulation of science here and what the prosecution has provided you. I want to talk first about forensic anthropology, please. Heard from a couple of forensic anthropologists, the terms got batted around a bunch. And those terms, I think you guys have taken notes, that you're going to have to grapple with here. Perimortem, what does that mean? Taphonomy, what does that mean? What is forensic anthropology? And forensic anthropology is basically PhDs in anthropology looking at bones and trying to figure out what kind of damage has been done to that bones and in what windows of time that damage is done and what, if anything, they can say about that damage. We don't know. The prosecution would have you believe that a partial cranium on the open range for after 2 years being subject to livestock, bears, coyotes, mice, birds, mountain lions, bobcats, birds, sun, more sun, rain, erosion, temperature changes, water runoff, and actually 3 years, that's my typo. You have a partial cranium that's been up in Runlet Park for that long, and it is covered in animal damage, but for the opinion of one forensic anthropologist that says 2 minuscule marks on the zygoma are concerning to her or suspicious, the prosecution would have you believe that this cranium that's been in the wilderness for years and years and years and subject to all sorts of natural taphonomic abuse, they would argue that those 2 tiny marks are emblematic of a father killing his son. And I submit to you that is not supported by the evidence and that is not supported by science. And you got an exhibit to look at that. It's on one of these poster boards where you can see this open range. See there were cattle up there. And even, you know, we'll get into what Dr. Francis' analysis was of this in a second. But we also know that on top of the cattle up there, we know from Daniel and Leah Foster where the cranium was found. And no, they're not wildlife biologists. They're not forensic anthropologists, but they are people who know how to walk through the woods and are good enough at it. They don't even need a trail, and they like going on adventures. They don't mind going into the wilderness area. They don't mind going into Runlet Park, but they also know how to protect themselves in those areas as well, and to make sure they don't get attacked by animals, that sort of thing as well. So they're vigilant, and they go out hiking in November 2015, and they find the partial cranium. Where do they find it? They find it in an area that they describe looks like a coyote den, where something would feed. And there's animal hair stuck on the trees around there, and there's grass pushed down. And as you might remember, they're kind of transplants, or at least they were in 2015, from Louisiana. They're still excited about seeing snow. So they went looking for snow. They go and find some snow not too far away from where they left the cranium, and they see bear tracks. And it's at that point, though they're not wildlife biologists, and though they're not forensic anthropologists, they see the bear tracks within spitting distance of where the cranium was, and they decide that their adventure, their hike is over for the day. They get out of there. We also know from when the Florida County Sheriff's Department went up there that they found more animal remains up there in proximity to where the cranium was found. Yeah. Dr. France. She made some findings regarding the remains
subcranial remains, or some, I guess I call them postcranial remains. That's all the bones she found from beneath the head. She noted the taphonomic, AKA natural damage to the cranium. She noted the animal damage to the zygomatic arch. On cross-examination, when I asked her, she said the cranium, when she received it in 2015. 3 years after, November of 2012, she said when she received the cranium, it was still in the perimortem phase. Let's review. Perimortem refers to that period in bones when they still retain the elasticity, bending, wetness of live bones. Now, why is that important? We'll get to that in a second. We also know from Dr. Kurtzman, the forensic pathologist, that Dr. France changed the cranium forever with her failed molding process, thus changing the evidence in this case forever after she was done with it. What do we remember about Dr. France? Very charismatic woman, very smart. Her mold failed here. She destroyed parts of the zygomatic arch. She denied that she changed those parts. She's not a tool mark expert, but she is a scientist. And she's a scientist who'd have you believe she's so eminently qualified to talk about what a dump site looks like, right? Usually where people deposit a body, based upon my anthropological experience, is that when bad people dispose of a body, they do it downhill, close to their house, by a road or a trail, and these are all theories that Dr. France believes in, she testified to you about. And she's also the architect of the, if you want to find a human head at the bottom of a hill, just throw a bucket off the top of it. We just do the bucket test. You just throw a bucket off the top of a hill, bucket will probably land next to a skull. You can consider these things in determining how much weight to give her opinions and her testimony. There were omissions from her report that she testified about in this courtroom as well. And even she offered no opinion as to cause or manner of death. And even she said that the fractures to the cranium are best, most conservatively explained by animal scavenging. Subcranial remains, a couple of femurs, a tibia, and a clavicle. Overwhelmingly, all the damage to these, and you'll get to see them if you want, done by animals. And what Dr. France told you, and what Dr. Bruce Anderson reiterated, and even what Dr. Kurtzman reiterated, is that the subcranial remains, the long bones in this, offer you no insight into what happened to Dylan, meaning there's no tool marks on there. There's no evidence of dismemberment on there. There's no evidence of decapitation on the clavicle. There's no evidence that there was body processing. All the subcranial remains, all taphonomic, natural damage, no evidence of trauma, no insight into circumstances surrounding death. That's Dr. France's testimony. The partial cranium, even Dr. France had to say and admit and own that there is massive animal damage to the partial cranium. Bite mark on the sphenoid process. We'll get there in a second. Bite mark on the inside of the cranium. On the inside of the cranium, not that far from where this fracture is as well. Scratches, marks, bite marks on the top of the cranium. The overwhelming amount of damage to the cranium comes from animals. One of the things she talks about is how there's a fracture along the coronal suture. You got the frontal. Talked about how there's a fracture, diastatic fracture, that runs along the coronal suture here. And what we know from all the experts who testified about these sorts of fractures
is that those fractures in the skull, like all fractures, follow the path of least resistance, which will be the suture. So the fact, and you'll see some pictures of this effect, the fact that the suture split, that just represents not blunt force trauma, but post-mortem animal predation, and that those fractures follow sutures, particularly in adolescents and children's skulls, because those sutures aren't as strong. Well, there was a lot of talk about the fracture, the frontal bone right here above the left orbit. Even Dr. France had to say that that fracture was possibly caused by animal predation, scavenging by either a bear, mountain lion, coyote, or even being stepped on by livestock. Each and every one of those qualify as blunt force, as perimortem blunt force trauma. And let's remember how Dr. France, their expert, defined blunt force trauma. It's either a bone hitting something hard or something hard hitting a bone. That's as good as they get for blunt force trauma. They're not going to provide you with a causation or a weapon or what happened. The best they can tell you, because they are restricted, as we all are, by science. The best they can tell you is something hit something and caused that, and they can't rule out any of those causes. Next, please. There's no impact, no depression fracture, no tool identified. Remember depression fractures? Those got talked about. Depression fractures happen when someone gets hit in the head by something pointy or by like a hammer or something like that, and it's like a little crater, a little depression in the bone. That would be consistent with someone getting hit by a tool or weapon or something like that. That doesn't exist on the cranium. Why is it important that in her expert opinion, after doing thousands of investigations like this and knowing perimortem coming and going, that when she received the cranium, it was still in the perimortem phase, it still had characteristics of live bone? Why is that important? Why is it important that there was still moisture in the bone? Because that means that if she says there was perimortem blunt force trauma inflicted on his cranium, any and all of those injuries could have been inflicted on the cranium up to the day they were found, and really up until the day Dr. France took possession of the partial cranium. That's a 3-year spread. We've talked about this enough, thanks. Oh, but we haven't talked about it quite enough. When you look closely at the fracture on the frontal bone, and this is a blow-up of one of the exhibits, you can see animal scratch marks, animal scavenging marks right where the crack is. So you'll be asked, you'll deliberate this, you'll talk about the issues as jurors. And you got to say, well, is there more evidence that this cranium, the head, Dylan Redwine, was hit by a weapon or a tool or an instrument or a table that no one has identified and can't identify? Or is there more evidence that this fracture comes from a cranium being in the sticks for 3 years, getting abused and fed on by animals? And I submit to you the evidence is clear from Dr. Francis and Dr. Anderson's own testimony what's going on with that fracture. Yeah, we talked about this too. Good pictures of the zygomatic arch. What Dr. France would have you believe, what the prosecution would have you believe, the 2 tiny marks here, right by where the bite mark is, are evidence of quote-unquote sharp force trauma. What we know, and I'll get into this in a moment, about Dr. Anderson's testimony, and I think he made it evident when you're talking about coyotes and bones, he's not to be messed with, that the fractures and the damage we see on the zygomatic arch are consistent with an animal grabbing that part of the skull by the zygomatic, just like that. And Dr. Anderson showed you that. And you can see what the other animal damage is. Now, you'd be able to have people 521 with you in the deliberation rooms too. And marks on the zygomatic root from animals does not mean with any sort of scientific certainty that there's going to be marks on the underside of the root, especially if the underside of the root ain't there, and especially if the animal that picks it up isn't carrying it around like a change purse. It's actually carrying it around like a meso carnivore. Like that. Next slide, please. Zygomatic arch was snapped off by animals. Marks on there could have been found up to the day it was found. Dr. France cannot identify what made those marks. A bladed instrument, a knife. What kind of knife? A bladed instrument. What was the width of the knife? What was the length of the knife? Did you look at the width of the marks? Did you measure those? No. Did we look at the width of the marks? No. No. There was a bunch of molding stuff stuck in there. So it's important to recall that, next slide, please. The marks on the zygomatic arch are literally millimeters away from where the zygomatic arch was snapped off by some sort of animal. This is where the damage begins, where it was snapped off by some sort of animal. These are millimeters, the blue one. We also know the marks, as they existed, and Dr. France got them, are thinner than a millimeter. We're talking about minuscule, it doesn't even come close. Very, very small marks, millimeters away from where some kind of animal crushed that zygoma. Yes. Oh boy. Dr. France gets the cranium, takes these pictures with her microscope. Then she applies some sort of latex silicone gunk to the cranium to make a mold because she knew it was going to get sent to Texas. And when she does that, she takes the silicone off and it forever changes these things so that everyone who gets to look at the marks afterwards, they look more like this, and they look like this, forever changing the state of the evidence. Now, she denies that happens. These are just different angles on the camera and just different lighting. You have the pictures. You can make your own determination. But remember, even Dr. Kurtzman agreed with the fact that the molding process changed what you guys get to look at during this trial. Right. So, cranium examined by Dr. France, goes down to Texas, gets positively identified as Dylan. Moves back to La Plata County. La Plata County Sheriff sends the partial cranium, actually hand delivers the cranium, I believe, to the Federal Bureau of Investigation, the FBI, as described by counsel, the best and the brightest. And they just don't take it to any sort of FBI substation. They take it to Quantico in Northern Virginia, where Special Agent Eric Smith works. And Agent Smith has been doing tool mark analysis for the Federal Bureau of Investigation, the best and the brightest in the nation at identifying what tools leave what kind of marks on what kind of materials. And after doing that for 20 years, they send him this zygomatic arch, the whole cranium, and they say, let us know if you think these are tool marks. And he says, consistent with a slicing cutting action, but he says, you can't determine if those marks were produced by tools, meaning man-made tools, or by the natural environment, by animals. And therefore, his analysis is, this is inconclusive. The best and the brightest FBI, when they look at the zygomatic arch, they're like, can't touch as animals or a tool. Now, La Plata County Sheriff's Department sent the cranium to the FBI before our team ever saw the cranium. We had to call the FBI witness to come in and testify from Quantico on TV They didn't call. We called the FBI because we wanted to arm you with that information. That was done on our watch because we thought that was useful information for you. They didn't call. The tool mark expert from the FBI. Dr. Bruce Anderson. He's testified as an expert on forensic anthropology about 12, 15 times, and has always done it on behalf of law enforcement. Working for the Pima County Medical Examiner, he's testified across Arizona, now Colorado, and even up in Idaho. And he's done so at the behest of prosecutors, law enforcement. He's even taught law enforcement, homicide investigators, how to process forensically and anthropologically human remains. He's processed more remains, more skeletal remains than probably just about anyone else in the field. And he's been doing so for a very, very, very long time. And he does it in Arizona, and they're going to make a bunch of hay out of that when they get to bat again. So I'm going to get there in a second. But in someone who has processed, examined thousands of human skeletal remains, he's of the opinion that the cranium was heavily scavenged, picked up by an animal, bitten by an animal, carried by an animal, seriously damaged by an animal. And he does not ascribe the fracture in the left part of the frontal bone or the two tiny marks on the root of the zygoma to any sort of peri-mortem man-caused injury. Quite the contrary. After looking at the entirety of the skeleton, at the evidence desk here, he determined that, without a question, this cranium was scavenged by animals and not sharp force trauma, not peri-mortem blunt force trauma. And he's seen animals take apart to see what the result is of animal scavenging craniums, particularly coyotes, more than anyone else. And he knows what those marks look like. And as he emphatically told you, he's very good at knowing what coyote scavenging looks like. And he identified the same animal damage here, and the same animal damage up here. And you'll get to look at that in the deliberation room. All the animal scratches coinciding with those diastatic fractures there. All the animal damage along the frontal bone, on the inside of the frontal bone. Next. Can I say, you saw him test right. Doctor knows about coyotes. And what the prosecution has posited is, well, those are desert coyotes. There's desert, and desert's wide open there, and the coyotes up in Vallecito don't do that, do they? Coyotes are coyotes. Whether they're in Arizona, whether they're in Vallecito, it's the same species. And they're motivated. We'll get into this in a second. We get into vertebrate biology, but they're motivated by the same sort of things, which is energy conservation, nutrients, and their own animal instinct. And what we know, and what Dr. Anderson told the prosecutors on cross-examination, and when they interviewed him, is that he can cite to over 100 times where skeletal remains from the same individual were 5 to 6 miles apart. And that he's been able to do that and has been leading the charge on those sorts of studies for several years. And that all flows from the fact that they can now take one part of the skeleton from mile 1 and one part of the skeleton from mile 7, test them for DNA and say these are the same person. And DNA has changed the analysis on how animals scavenge and disperse remains. And that's in sharp contravention to one of his grad students to whom he advised, who said that 88% of the time, cranium's always found with remains. Dr. Anderson disagrees with someone who we talked about all of this. Another view, same shot, animal damage right on the zygomatic arch. You'll have a chance to look at that. And you'll get a chance to look at all of these. And the point I'm trying to make here is that the evidence of any sort of blunt force trauma being inflicted on Dylan, the 13-year-old boy, by Mark, is not even scant. The damage that you've seen and been testified about this is overwhelmingly caused naturally in the environment. Still, next. Dr. Kurtzman, the forensic pathologist. He told you about his definition of homicide, which is a death caused by someone else, not caused by themselves. And what we know about Dr. Kurtzman is that he wasn't officially brought onto the case until 2018. He had heard about the case. He went to go look at some subcranial remains back in the day, but he wasn't brought on to the case until 2018. And he had to rely on a lot of different materials in his determinations about what happened to Dylan Redwine. And those materials included, and were all provided by law enforcement, a map depicting Middle Mountain Road with locations and distances that they think are relevant. The La Plata County Grand Jury indictment, the probable cause affidavit for the extradition, a timeline of electronic devices, some work products drafted by Jim Ezell and Tony Goldbright, the drawings of the Redwine house that showed the supposed dog alerts, photographs of where there were luminol hits in the house, photographs of where the dog supposedly alerted on the truck, a composite skeleton, it's actually one of their exhibits, of what was found up on Middle Mountain. So he's asked to deliver a scientific opinion about cause of death and manner of death. And he doesn't look at the remains officially to do an actual analysis until 2018. And obviously there's not a lot of remains here. That's undisputed. So he's got to rely on basically 10 other reports drafted by the prosecution saying, hey, we found luminol here. And hey, there